Good morning, everyone. My name is Christian Waugh. The time is 9:03, and I hereby call this Citrus County Code Compliance hearing to order. We follow an agenda for these hearings. The first item on the agenda is the call to order. The second item is the pledge to the flag. So I'd like to ask if you join me in the pledge to the flag. I pledge allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you all.
Good morning.
Good morning.
If any person decides to appeal any decision made by the Code Compliance Special Master with respect to any matter considered at this public hearing, he or she will need to ensure that a verbatim record of the proceedings is made, which record shall include the testimony and evidence upon which the appeal is to be based.
The next item on the agenda is approving the minutes from the May 2023 Code Compliance hearing. Are there any objections to the minutes as currently formulated? All right, I review the minutes and I hereby approve them.
Staff update, continued and abated cases are listed out front.
All right. Again, good morning, everyone. My name is Christian Waugh, and I am a licensed Florida attorney acting as what is called a special master. That's a fancy title created by law, but what it means is that Citrus County has hired me to preside over this hearing. A couple things about the hearing itself. One is, just so you know, everything is being recorded. This will be posted to YouTube on the Citrus County channel. Another thing is I will probably take breaks periodically depending on how long this hearing goes. I don't expect it to be particularly short. I am mindful of your time and the fact that you probably have better things to be doing than to be here today. So I expect to take a break every hour and a half or so, just so you know. But when your case is called, please come forward and you will be placed under oath. If you are appearing at a hearing like this for the first time, I'll state the alleged violation and allow the county to present its case first. You will then have an opportunity to present your case regarding the violation, which may include evidence if you wish. During this process, the county attorney's office or myself may have questions of the parties, witnesses, or staff. I will ask if there are any members of the public who wish to speak, and if there are, such members of the public will have one opportunity to speak per case. Such right to speak is not unlimited, and public comment should be focused on the case and made as succinctly as possible. It is not an appropriate forum for insults. In most instances, if you are found guilty of a violation, the law requires that you be given time to comply before a fine begins. You must abate the violation by that date, that is, fix the violation, or the fine will accrue for each day that you remain in violation. The law then allows Citrus County to impose that fine as a lien on all real or personal property that you own, and the county may foreclose on that lien or seek a money judgment against you after the lien has been recorded for 3 months. This is important because I may not give you another date to appear before me, and therefore you likely will not have another opportunity to plead your case or to explain why you didn't comply with the county law. In all cases in which I find someone guilty of a violation, I will impose all costs required by county law. If you abate or fix the violation at the time allotted, that cost remains minimal. If you do not timely fix the violation, you'll be responsible for additional costs as well as the cost of the lien imposed. If I find you guilty of a violation and allow for a continuance of your case, you'll be required to return on a certain date. In the time between hearings, I will require that you comply with the county law in order to consider the violation resolved. If your violation is not resolved by that next date, I may impose a fine for each day of the violation from today's date forward. Your failure to return may be deemed evidence of your failure to cooperate with the county. I don't think we have any appeals of orders to demolish. Okay.
No.
Ladies and gentlemen, you do have the right to appeal any order that I make today as provided by law. Thank you.
First case on today's agenda, CFA Properties, MGM LLC, case number 218-5251-15, Code Officer Alan Jonathan, page 10 of your agenda.
Morning.
Good morning.
Alan Jonasson, Citrus. Oh, I'm sorry.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Alan Jonasson, Citrus County Code Compliance Officer. This is case number 218-5215, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. Address of the violation is 3860 East Kirk Street, Inverness, Florida. Property owner is CFA Properties, MGM LLC. I have good service via posting the notice of hearing on the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on 23 March 2023, photos from a compliance inspection on 24 April 2023, and photos of my final inspection conducted on 20 June 2023. Exhibit B, a copy of the notice of violation for the registered agent and the LLC, a copy of the notice of hearing for the registered agent and the LLC, a copy of the posting affidavit, and a photo of the notice of hearing posted on the property.
Okay. Is there anyone from the public who's going to want to be heard on this case? All right, let the record reflect that there's no response. Without objection, what's been proposed as Exhibits A and B are evidence.
On 23 March 2023, I conducted my initial inspection and observed the property to be in violation. On 23 March 2023, a notice of violation was issued for junkyard conditions, which is a violation of the ordinance listed above. On 24 April 2023, I conducted a compliance inspection and observed that the property remained in violation. I have not had contact with the property owner, and as of my final inspection on 20 June 2023, the property remains in violation.
I think it's pretty clear cut from the evidence. What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $100 per day, along with the administrative cost to begin after the date you deem sufficient to abate the violation. This amount was selected based on the actions of the property owners once they were advised of the violation. We would also ask that the special master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
Well, the other thing about the evidence is it doesn't look like it's that huge, so it shouldn't take that long to actually fix. I will find that the property is in violation and adopt the county's proposed findings of fact. I'll grant 15 days from today to abate the violation. Bless you.
Bless you.
If the violation is not brought into compliance as ordered, a penalty of $100 per day will be imposed. This fine will be recorded and constitute a lien on the real or personal property of the owner, and I incorporate the other standard order provisions.
Thank you.
Thanks.
Next case on the day's agenda, Nolan Delmas, case number 218-6356, Code Officer Alan Jonasson, page 12 of your agenda.
Alan Jonasson, Citrus County Code Compliance Officer. This is case number 218-6356, accumulation of junk and
Do you have
debris.
somewhere to be, Mr. Jonasson?
I do not.
Oh,
I
okay.
do not.
I'm
just a chosen one today.
okay.
It's the hair.
All right. I was just curious why the order. I know we have people.
Phones.
Okay.
For our office, we're short, so that way.
Okay. Gotcha.
Cover
All right.
phones.
Fair enough.
Case number 218-6356, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address of the violation is 4584 North Custer Terrace, Hernando, Florida. Property owner is Delmas Noel Ann. I have good service via posting the notice of hearing on the property and posting at the Lecanto Government Building. Would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during an initial inspection on 10 April 2023, photos from a compliance inspection on 10 May 2023, and photos from my final inspection conducted on 20 June 2023. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the posting affidavit, and a photo of the notice of hearing posted on the property.
Is there anyone from the public who wants to be heard on this case? All right. There isn't. Without objection, what's been proposed as Exhibits A and B are evidence.
On 10 April 2023, I conducted my initial inspection and observed the property to be in violation. On 10 April 2023, a notice of violation was issued for junkyard conditions, which is a violation of the ordinance listed earlier. On 10 May 2023, I conducted a compliance inspection and observed that the property remained in violation. I have had contact with the property owner, and as of my final inspection on 20 June 2023, the property remains in violation.
What did the owner say?
So the property owner was trying to help somebody and let them store their junk and debris on the backside of her property. Since then, since the notice was sent to her, it has almost all been cleaned up. She's made significant progress in getting it cleaned up. She said it would take her probably another 3 or 4 days before she was finished.
I agree. I mean, I actually didn't see. I almost didn't see a violation, but then you see in the back, and
Yes, sir. That's where the majority. That's where.
yeah,
the violation.
there's very little left, but yeah, I agree. Technically, it's still a violation.
And she's been very communicative, very good about getting it.
Did you ask her what that noose was for?
I did not. I don't. So this lady is partially blind, and I'm not for sure that she knows that that's there. But I will let her know.
Just curious. Yeah, I mean, it could be dangerous for her or someone else. All right. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day, along with the administrative cost to begin after the date you deem sufficient to abate the violation. This amount was selected based on the actions of the property owners once they were advised of the violation. We would also ask the special master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
I'll adopt the county's proposed findings of fact. Because of the cooperation from the owner, I'll grant 30 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. And I otherwise incorporate the standard order provisions.
Thank you.
Thanks.
Have a great day.
You too.
Next case on today's agenda, Jesse Dustin Aaron, case number 218-2353, Code Officer Brandon Norman, page 4 of your agenda.
Good morning.
Morning.
Mr. Aaron, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do. Good morning.
Morning.
Brandon Norman, Citrus County Code Compliance Officer. This is case number 218-2353, abandoned unserviced unlicensed vehicles, a violation of Chapter 20, Article 4, Section 20-41 of the Citrus County Code of Ordinances. The address is 13213 South Oakview Avenue, Floral City, Florida 34436. The property owner is Aaron Jesse Dustin. I have good service via certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Photos taken during an initial inspection on February 27, 2023. Photos taken at my compliance inspection on April 6, 2022. And photos at my final inspection on June 19, 2023. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, and a copy of the signed certified mail return receipt.
Sir, well, first of all, let me ask, is your last name Aaron?
Yes.
Okay, I just want to make sure. And so you're Jesse Dustin Aaron.
Correct.
Okay. And I'd like to ask you to take a look at the documents he just talked about and to take your time doing it. He's proposing to use these documents as evidence in the hearing, Exhibits A and B. If you have any objections to them being evidence, I'd like to know.
No. Can I keep this copy?
No, but you can make a records request for
Okay.
copies.
All right.
Am I right about that, Ms. Antrim or Ms. Harrison? Okay.
Can I look at these for a minute? I'm just,
These I have to keep. Just like if you had proposed evidence, I'd have to keep that too.
okay. Okay. There. I mean, I have a question. So when I received a letter on the 15th, I contacted your office or this office, asked for a return call, gave them 2 cell phone numbers, and it was emailed to my email address. I didn't receive any emails. I did email yesterday, got an email back and a phone call shortly after, which we spoke. So since receiving that, I didn't receive anything. I thought the matter had been dropped. Those are race vehicles. Even the buses are race vehicles. I put the show on.
Well, if you don't mind, I'm not even sure what the county is actually presenting yet.
Okay.
That's why I always, and this so everyone knows,
Okay.
I always let the county present first because I'm actually not sure what they're even saying about you.
Yeah.
I don't want to know your response until I know what they're saying.
Okay.
And that's the one basic requirement I have is you have to be heard.
Okay.
You have to have a chance.
So, other than the contact, the first time I spoke to him was yesterday.
Well, no, so my only question to you right now was, do you have objections to these documents? For example, the photos. Do you have any reason to believe that these are not accurate photos of the property on the dates that are listed?
They're accurate. I mean, it changes daily in my driveway.
Sure.
It changes daily.
And then, so that's Exhibit A, it's the photos, right?
Okay.
And then Exhibit B is the notice of violation that was, I think, posted on the property and mailed.
The notice of violation was mailed to the.
It was mailed, and you said you
Actually,
got
I was
it.
signed for it at the post office.
Right, okay, so you,
We got it I got it, received it on the 15th of March.
okay, so that's
14.
basically Exhibit B is that documentation.
Okay.
So do you have any objection to these documents being evidence?
No, I got the notice on the 15th that I signed for, and then while I was in the hospital recently, we received the one from about the hearing.
All right, so that settles that. I'll let the county, then without objection, what's been proposed as Exhibits A and B are evidence. What is the county's case?
On February 27th, 2023, an initial inspection was conducted of the property for unlicensed and inoperable vehicles at the property and was found to be in violation of the mentioned ordinance. I observed several buses, vehicles, and trailers that appeared to be inoperable at the time. I conducted a compliance inspection on April 6, 2023, and observed no change. I did attempt to contact the property owner when I received that first message from our secretary. I got no response back. I wasn't able to leave a voicemail.
So your attempt to contact was a phone call?
Affirmative, yes. At my final inspection on June 19th, 2023, the violation remains on the property with little to no change. I have had contact with the property owner as of yesterday. We did speak. We talked about ways to bring the property back into compliance.
Okay. Now, before I turn to you, I want to look so I just need to look at these photos to see if I can well, okay. I think I see where they're coming from, and I see where you're coming from already. So, how big is this piece of property?
5 acres.
5 acres. All right. You can do a lot with 5 acres.
That's why I don't bought it.
Well, tell me, so from your perspective, what's going on? I mean, do you understand what the county's saying?
I know where the complaint come from. I know why the complaint's there. It's another issue prior to this over not this.
Yeah.
So I know it's a civil matter, has nothing to do with this. I understand that.
Correct.
The reason I contacted the office the first time was to find out how I need to comply because I'm kind of faced with a little bit of dilemma. A 6-foot fence is not going to cover that. My property also runs uphill to the back of the 5 acres. I'd have to build a 24-foot fence.
I don't think the fence is the problem.
so
am I wrong? Would a fence actually fix the issue?
We don't encourage anyone to prevent the view of violations. We encourage everyone to abate the violations, so to take care of
No,
the
my point
inoperable.
is he's talking about putting a fence. So would a fence that obscures the view actually fix the violation?
No, sir.
No.
So my question is on a recreational vehicle such as race cars, race buses, things of that nature, boats, whatever. I spend thousands of dollars at the county office every year registering my tags on my trailers, trucks, boats, RVs, things of that nature. I need, obviously, and even a lot of these pictures, you can't even see the tag because of the way the trailer was parked sideways.
Are these like vehicles that are used in like monster truck rallies?
We do the Citrus County bus show.
Show. Okay.
I run all the buses that run that show.
Gotcha. So are all these vehicles tagged?
No,
Okay.
no, I mean
Well, yeah, I mean, you just have to explain it to
Yeah,
me.
I mean,
So
that's
most
why I had trailers, so many trailers, is I had 30-foot trailers and 40-foot trailers to haul those.
to haul them. Okay. Okay, that makes sense. I see the trailers. I'm just reviewing the code section. It's interesting. Can you tell me about the bus show?
So the bus show, and they do a bus figure eight show at the track here like 5 times a year, and obviously we tear them up and stuff, and I have to fix them in different stages or whatever. But we load them up. It's 5 times a year. We take them over there. We do the show, and we bring them back the same night.
What happens to them at the bus show? You said tear them up, but like what happens?
Well, I mean, they figure eight race, so you drive through an intersection with no red lights. I mean, it happened. There's one on, recently. It actually happened last 2 weeks ago.
Is there a zoning or something that would allow him to keep these vehicles on there the way that they are? Despite the code I see how the code section applies, but is there, because if this happens and, there's no way to have this bus show, because I don't know where you'd put all these vehicles if they weren't allowed to be somewhere.
Could I request that the land development director come up and speak?
I'd
on the
love to
zoning?
hear from the land development director.
There's
I just
also-
know that it's zoned rural. I know that it's 5 acres. I know that there's no variances in places for what's occurring on the property at this time. So
I'm just curious. I'd hate to say that something's a violation if it's like related to a cultural event
Do you
here,
swear to
but
tell the truth, the whole
And
truth,
section
nothing but the truth, so help you
20-42 contains the exceptions.
okay, 20-42. I'm sorry, Ms. Couture, let me just look at this real quick. Oh. So actually, a 24-foot fence would create an exception? I mean, I'm not proposing he build a 24-foot
No,
fence.
and the fencing provision is a little vague because it says,
It is vague.
because then it goes on to completely enclosed garage.
But the key part was completely shielded from view or entirely within the confines of a completely... Oh, I see what you're saying. So you're saying the completely shielded from view could... well, look, the way I would read it, I don't know how I'd read it. I see your point.
Yeah,
but at the same time, there's no
not well
garage.
written.
There's no garage that can house all these.
And the fencing would, I guess we'll defer to Ms. Couture about the
Yeah.
fencing.
What do you think?
For a residential site, if you're going to have vehicles, and these are figure eight buses from what I heard, so they're junk, you can't have a junk
But junk
yard.
we love.
We do. I think that'd be kind of cool to see,
Yeah.
but that's not the issue. There are junkyard zoning districts. They're commercial. They're not this residential. So if you've got a residential thing and you happen to be working on a car that's not running or something, it has to be fully enclosed, shielded from view. And so I don't know if a fence will cover this many. It's not meant for commercial operation. It's meant for, somebody working on a car, whatever. It's certainly not meant for the volume that you're talking about, but if you could completely close it and shield it, sure. But this would have to be a junkyard, and those are different zonings.
Well, I want to be sure I understand what you're saying, though. So here I don't see anything talking about zoning on 20-42, which is the exceptions to this code section. I do see a part in the exception talking about vehicle, provided the vehicle is the property of the owner or occupier of the land, and that such use is not a commercial use of the property. I don't know if it contemplates this kind of a...
It doesn't.
Yeah.
I agree with you on that, and I also think Ms. Andrews' point is taken. You have some exceptions, and he can try to fall into those for a few. It's clearly not designed for this kind of volume.
Okay. Thank you. I appreciate it. Does the county attorney's office have any other input?
I would just say otherwise they would have to be stored at a storage facility.
So here's the way I view this, and you've presented an issue I've never seen before here. I think that the exceptions do apply to you if you can find a way to satisfy the exception. And so I had initially at the beginning said, talked with Mr. Norman about it, that I didn't think a fence would actually protect you. I think it might, if you completely shielded it from view. You're telling me that's impractical.
Not impossible. I can do it.
Well, at the end of the day, I am going to find that as it stands, there's a violation. How much time do you think you'd need to either move all this to a storage or a junkyard place, or to satisfy Code Section 20-42 for the exceptions, or otherwise get rid of the stuff? How much time do you need to fix the violation?
Could I get 45 days?
Yes. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with the administrative cost to begin after the date that you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask the special master additionally to find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
I'm going to make a finding in the order that my interpretation of 20-42, exception 2, is that it's a disjunctive, that the storage, service, or repair of inoperable or unlicensed vehicles may be completely, if they're completely shielded from view, then that satisfies the exception. For now, I mean, that may change in the future if they amend it, who knows. But given that, I am going to find that there's a violation of Code Section 20-41. I'll grant 60 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. And the rest is standard order provisions about how, if this proceeds, you'll be responsible for the costs and all that kind of stuff. So that's it.
Thank you, sir.
All right, thank you.
Thank you.
Next cases on today's agenda, Norma Jean Bianchi and TJ Suttles. Case numbers 218-6065 and 218-6066. Code Officer Julie Wilkinson, pages 5 and 6 of your agenda.
Good morning.
Hi, good morning.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Can you please state your name for the record?
Norma Bianchi.
Thank you.
Julie Wilkinson, Citrus County Code Compliance Officer. Case number 218-6065, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. And case number 218-6066, unlicensed inoperable vehicle, a violation of Chapter 20, Article 4, Section 20-41 of the Citrus County Code of Ordinances.
Are you presenting both cases at the same time?
Yes.
Okay. Ma'am, do you understand what that means? So we're doing the hearing for both of the violations at the same time.
There's no inoperable vehicle.
I understand. So we'll get into what you're saying. Well, I just want you to know what the county's doing is they're presenting the inoperable vehicle case as well as the junk case at the same time.
That's fine.
Okay, that's all. We'll get to that. All right, go ahead.
The address is 6155 West Cardinal Street, Homosassa, Florida. Property owner is Bianchi Norma
Good
Jean
enough, yeah.
and Suttles TJ.
That's who I bought the home from. He died.
Good service via posting the notice of hearing on the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during an initial inspection on April 3rd, 2023. A corrective action inspection on May 4th, 2023. And photos of my final inspection conducted on June 20th, 2023. Exhibit B, a copy of the notices of violation, copy of the notices of hearing, copy of the notices of hearing posted on the property, and a copy of the posting affidavits.
Do you have separate exhibits A and B for each case?
Yes, sir.
So, ma'am, as you've heard already, I like to hear from the county first before turning to you. But At this point, what the county has is 2 sets of documents for each of the cases. They have an Exhibit A and B for one case and an Exhibit A and B for the other case. I want you to take a look through these documents
That's fine. I
And-
have the Exhibit C.
and let me know if you have any objection to these documents. Just let me know what your objections are if you have them. And take your time.
We already tagged it, though. You already knew that.
Yeah.
So you can talk about that, but they're proceeding with this case, so I have to hear the county's
fine.
perspective on this. I really would ask that you look through the pages to make sure you don't have any objection. This is your opportunity to be heard. And while she's doing that, are there any persons who want to be heard from the public on this case? Right, I don't see any.
Who else would be heard? I'm the only homeowner.
Well, actually, sometimes people from the public come and they have a right to be heard.
Yeah, my Connecticut snowbird neighbors, every time they come back, they call and report something.
There you
But
go.
they
So-
won't show their faces, because they don't want me to
well,
know.
every now and then those people do show up.
Yeah, they can fucking go to hell.
Excuse me?
Sorry, I said they could go to hell. Sorry.
Oh. Well, they'll have to get in line.
Oh, I'm sure. Ever since I bought this home less than 2 years ago, they reported me for making a back porch deck and putting in an above ground pool, just everything.
People are often surprised that in the free state of Florida that there are so many rules and
I called
things.
code enforcement, and there was an awesome guy named Matt that was working here, and I would always check with him before doing anything. There you go. Now I can't even make a pile of wood next to my chimenea without someone taking a picture and putting that on a.
Well, we'll get into it. All right, so I haven't heard objection to Exhibits A and B, although I've heard there's an Exhibit C. So I'll admit A and B into evidence and let the county proceed at this time.
Okay. On April 3rd, 2023, I conducted an initial inspection and observed the property to be in violation. On April 3rd, 2023, a notice of violation was issued for junkyard conditions and unlicensed vehicles, which is a violation of the ordinances listed above. On May 4th, 2023, I conducted a compliance inspection and observed that the property remained in violation. I have had contact with the property owner, and as of my final inspection on June 20th, 2023, the property remains in violation.
And how do I pronounce your last name? Bianchi?
Bianchi.
Bianchi. Before I turn to Miss Bianchi and before I look through all the photos, you said you had contact. I presume that's with Miss Bianchi.
Yes, sir.
Okay. And have you noticed improvement since you started this?
Yes.
She said she's come into compliance already with one of them.
Yes, so there has been improvements. The initial issue with the unlicensed vehicles was both for the inoperable boat that's in the front yard and for the RV. The RV had expired tags.
Okay.
Since then, the RV has had new current ones put on. The boat was moved to the backyard, but it's still visible and it's still inoperable, so it's still in violation.
I'm looking. So, Ms. Bianchi, let me handle the unlicensed case first. Let me just take a look at this because I think that'll be easier. All right. Well, Ms. Bianchi, the boats are subject to the ordinance. Is the boat still?
Can I show you pictures?
Yeah, I mean.
Because everything, I moved it to the backyard, which is behind another cattle gate.
Yeah.
And I have a picture from the road where you would be standing, and you can probably see like maybe 1 foot of
Oh,
red
I see what you're
color
saying. I see. Well, let me.
because it's behind
well,
the gate.
I actually had to really look
And
at
I
the photo.
started turning it
Yeah.
into a garden now. When she came by yesterday, she didn't notice any flowers or flower pots because she can barely even see the boat. That's the thing.
Well, I could barely see the boat, but I could see it.
That's in the front, and now it's in the backyard. And
No, there's a photo.
did she go between the two properties? Because that's only
How
like a
did you
1
take the
foot.
photo?
From the right of way on the side of the street.
From the right of way on the side of the street. So let me talk to you first about your photos. If they're on the phone, I can't take evidence unless it's something I can put into the record. In other words, they'd have to be printed unless I take your phone.
Got an email?
If the county received an email and they printed it, but we're here at the hearing, where is the right of way that you took the photo from? It's from the front of the yard?
Yes.
Okay.
That's where I took my picture too. This morning before I even, yeah.
Here's the thing. I can barely see it. I can see a sliver though.
If I put a 4x6 right there, you won't be able to see it.
So let me read the code section. It's just so we're on the same page. I'm just going to read the exception part because that's relevant here. The storage, service, or repair of inoperable or unlicensed vehicles that are completely shielded from view. Okay, that's it. That's the exception. So if you do want the exception to apply, it's got to be completely shielded from view. And it's not there yet. I'm just,
No, that's fine. I'll just take my cattle gate back down because I can't fit my dually through there. So I'll just take my gate back down and pull the boat further around back.
Well, there's different ways of doing it, but the point is...
But she had said that if it's visible from a back road too, then it's a violation. That's a dead-end back road behind me. I don't know how to win with this. Do I throw away everything that I've paid for?
Well, that's interesting. So
The
what are you
only
saying about
reason
the
I
back?
can't get a tag on the boat right now is because it came from a foreclosed home where the owner had passed away, and the family was giving everything away. That's how I got the boat.
Right.
And it's a Florida boat, but I just haven't had time
Yep.
with remodeling my old trailer that I bought on the half acre, and I haven't even been there 2 years, and I'm trying to keep up with code now.
Well, let's figure this out. So is there a road behind the property?
Well, I'm unfamiliar if there's a road behind the property, but I told her that if I can see it from her neighbor's yards, it's still in violation.
Mm-hmm.
My neighbors have a 6-foot privacy fence up around the backyard, so unless you're in the front yard staring through my gate, you wouldn't be able to see it from their side. You could walk down their driveway and can't see over unless you're over 6 foot. So, because it's a white privacy.
Well, I'm not gonna rule on that. What I am gonna find is that at least on the boat case, it's technically a violation. It's either got to get completely shielded from view, or you got to get the tag. So I'll give you enough time to do that. How much time?
When I'm off work, I'll just pull it further behind the home.
I don't know if that's going to do it. But
I know, because
how
then
much,
if you go on the right side of my
Ma'am,
trailer and look down by
if
that
you would,
neighbor.
how much time do you need to either enclose it from view or get the tag?
I don't know what kind of issue I'm going to have with getting a tag right now. So, and I work so much every weekday for the garbage company. By the time I get off work each night, everything's closed, and just until the 1st.
Well, I can give time. It's just got to be a reasonable amount of time.
Turning it into like a kid's play yard toy. Could I just say that's what my boat is? Or, turning it into a garden didn't work because I didn't pour the flowers and soil into the boat.
I don't know if that would. Well, no. Let me put it this way. That won't do the trick. To put a bunch of dirt into it.
Yeah,
and
I
then
was told I could turn it into a garden, a flower bed. But
is that true?
I had suggested that. I may have been incorrect in saying that.
Well, we did have a case.
Because I put flower pots and everything on it, I don't want to dump a bunch of soil on my boat,
Then let me just say that's a very, very, very tricky legal question. We've dealt with it recently in another context, and the issue was whether or not junk in a front yard could be art. It's possible.
I've seen it on busy roads,
Right. In this case, it wasn't. It was not art because it wasn't transformative. I would think that y'all really need to talk to the county about whether or not that's one of the solutions. I'm not gonna pre-rule.
My youngest kid is 14. What if it's a play yard toy, like a slide? You know, I mean, what
A
if?
slide, a boat that's a slide.
Well, not the boat being a slide, but I mean, what if it could be like a jungle gym, a toy? You know, freaking people have power wheels and dirt bikes and everything. You know, why can't a boat be something to play on? Could it be considered that? I mean,
Well, I think from the county's perspective, we've seen cases where there's junk cases and most of it's kids' toys in the yard. Not always. I mean, if there's a bunch of kids' toys in the yard, if they're bringing a junk case, usually there's other debris and stuff. I've never seen it just be kids' toys.
Can I?
Yeah, please.
The only thing I would think with that is then you get into the situation that, it's going to be, it could get damaged or it's going to be modified, or then it could be, turned into junk in a sense. And so when you start changing stuff, and that may get you into another violation.
I don't want to change the boat in any way, but if I can have it considered as a kid's plaything.
What's the issue with getting a tag? I guess I don't understand that.
I'd rather the boat sit like it is until I'm ready to restore it. It's a 1959 Chief Thunderbird.
My question was, I don't understand the problem with getting a tag.
I haven't even made it that far yet because I'm not finished with my roof, which I'm pulling permits for. Right now, I'm almost done stripping it.
Is there a code violation on the roof?
No.
Okay, you've got a code violation on the boat. So, I mean, I would just say, look, I mean...
I'm trying to remodel the 71 trailer that I bought like a year and a half ago. And, the boat was going to be the least of my worries till now.
I know. You're here on a hearing. It's a code enforcement hearing. And I kind of don't want to talk about this other stuff anymore. I want to focus on the boat. And so my question really is, I mean, I need to know how long. I'm going to find that there's a violation. So what I need to know is what's the time you need to fix it. One of the ways you can do is by getting a tag. You don't know how long it'll take, so I'll guess. I would guess on how much time. This isn't something that's affecting the health, safety, and welfare of your neighbors,
I don't have a title or bill of sale. I do have the number for the people who gave me it
Right.
when they bought the property.
So that's a start. All right, so let's now talk about the junk case. Let me look through these photos because it looks to me like...
The roll of fins, the paint buckets, everything's been moved. I have pictures right now where it's all gone, you can't see anything. Since I got off work yesterday. I took no
Frankly,
pictures after
the
cleaning up
county's
more.
pictures show the same thing. I mean, what's the violation?
Was a lot of miscellaneous junk and stuff out when I first got there on my first inspection. She has done some cleaning up, but when I went there yesterday for the final inspection, there was new trash outside of one of the campers that was overspilling onto the ground. There was still some 5-gallon buckets, and she also had her recliner and some other trash out for garbage collection, which you can't have out for more than 48 hours.
Has it been out there for more than 48 hours?
It's been out there since
Yes.
last week, and she
Okay.
told me yesterday it's not going to be picked up until next week.
I was 2 weeks behind to pay the bill for
Sure.
the pickup,
Yeah.
so. But I got that covered and it's Mondays, so.
Okay, so this is a case as well where
The trash is more cleaned up now. too,
Ma'am,
when
if
it's
you
all
don't
in
mind,
bins.
hold on a second. So this is a case as well where you're very, 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 very close. Like, it's very close. The stuff in the front just has to get picked up, and the part that's near the camper, it's got to be enclosed and put out for the trash. You have a garbage can that's overflowing with cans.
Yeah.
It's got to be enclosed and it's
Well,
got to be put out.
I've never had that much garbage before. That's because of getting a couple weeks behind on paying
No, I
the
get
bill.
it. What I'm talking to you about what remains to be done. All right. So it doesn't take that much. I am going to find that there's a violation because technically there is, but it would take hours to fix.
I did a lot yesterday when I
Yeah.
got off work, and that's what I took pictures of.
I have
So,
photos too of yesterday, and it looks good.
This
It's
is
just
in the
not
evening,
perfect.
so it looks even better.
Well, but
So.
you've conceded there's a violation because you conceded the stuff that's out front. So I don't even have to rely on photos because you conceded it.
Yeah.
But which I appreciate your honesty. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day per violation, along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. We would also ask the special master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
Okay, so ma'am, based on your feedback, in case number 2186065, that's the unlicensed, in case number 2186066, the unlicensed vehicle case, I'm going to grant you 90 days.
Excuse me, what's the unlicensed vehicle?
That's
the
the
RV?
boat case. It's
Oh,
the
the
boat.
boat. All right.
Okay, I'm going to grant you 90 days to bring the property into violation or into compliance. And if the violation is not brought into compliance as ordered, a penalty of $50 will be imposed per day. So you've got 3 months to figure the boat situation out. I think that's enough time to either get a tag or satisfy the exception. In the other case, the junk case, there's almost nothing left for you to do. I'm going to grant you 15 days to clean it up and just make sure you get it off the property. If you don't get into compliance within 15 days, similarly,
Sorry,
a
what
penalty
exactly-
of $50 per day will be imposed, and that's how that'll work. Go
Other
ahead.
than the trash that's by the road, which is all cleaned up now, but what else was it on the property that needs to be done?
Any other junk and debris?
My drum set, that's
No,
before
that's,
I moved into my
I don't
house,
consider the drum, I'm not, is the drums, do you consider the drum set part of the case?
I haven't considered it part of the case, and I told her that from the beginning.
Yeah, it's not, the drum set's not involved.
Yeah, no, that's back inside, I'm still in the process of moving stuff out of storage too, So every day you come by, there's gonna be something new to get a picture of. It's just,
Well, this is junk and debris, so
Yeah.
according to the evidence in front of me, it's the stuff in the front of the yard, and it's the stuff that was next to the camper that wasn't enclosed.
my 5-gallon paint buckets and that my rolls of fence are already gone because the paint's in the shed and the roll of fence I just finished putting up.
Then you're good on that.
So,
All right, this hearing's over. Thank you.
Next case on the day's agenda,
can I go to work now?
Joseph
Do I have to
Darmington,
wait?
case number 2165144, Code Officer Jillian Nocella, page 11 of your agenda. Expert on the case, Joanna Coutu. Officer Nocella is out today. I'll be standing in her place.
Okay. Which case is this?
This was,
Oh, page 11, okay.
Do you swear to tell the truth, the whole truth, and nothing but the truth? So help you?
I do. Good morning.
Good morning. Can you remind me where we're at on this case?
Yes, sir. This was a fine appeal, and it was continued from last month's hearing. I think you needed more research or more information.
Let me just review what's in the notes here. So normally in a fine appeal, my review is fairly limited. It's to determine whether or not there was a basis for the fine, I think, in the first place, and the amount of the fine. In other words, was it brought into compliance or not? And this was a case, if I recall, where there were, do you remember what his argument was for why the appeal?
From the dates of which we stated that he was out of compliance.
Correct.
He was stating that he was in compliance.
Right.
And I think you may have wanted another testimony from
Well, the
staff.
testimony
I
I
don't know if that's
wanted, I
necessary.
know what testimony I wanted. The testimony I wanted was there were allegations that he was uncooperative. I don't know how much it matters for the purposes of a fine appeal. In other words, I can't retroactively increase a fine for, is Mr. Darmiento here? Okay. I mean, look, I know he was here when I continued the hearing.
Yes.
I I do want to hear the testimony. So what was the nature of the interaction between Mr. Darmington? And I know I wanted to hear from Ms. Spiros as well. So, Mr. Charlton, do you have testimony to offer regarding the interactions?
I gave it last time. I don't know if you
Put it on,
if you want
but I don't think you were as specific as you could have been.
Okay. Yeah, this case went to hearing last year. It was given 240 days to abate the violation, and that would have been April 18th, 2023. I wasn't the officer assigned to the case, but he kept insisting to speak with me as the director, which was fine. I explained to him several times that we were going by the order that was given from the special master. They continued to state that it was something personal. I don't know. Our goal is compliance. There was a lot of yelling and screaming, cussing, like stated, racial statements that he stated.
Like what?
That he's gonna hit me in my mouth, effing nigger. So that was stated. We'd have to hang up.
That was on the phone?
Yes.
Okay.
Yes. We tried to explain the violation and how he could abate the violation.
Okay.
To no avail at times.
The reason why I think the testimony is important is that I want to hear from both sides on the full nature of the interaction, because that affects the case. It's not going to affect the amount of the fine appeal, but I think it bears on the credibility of the witness. And every now and then we do hear things like this. My understanding is that there was interaction between Mr. Darmington and Ms. Spiros as well. Is that correct?
Yes, sir.
I'd like to hear the testimony. Yeah. Can someone swear her in? And
You can swear me, can you?
I'll swear you in.
Okay.
Can you raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay.
Can I read?
What's your name?
Lori Spiros, Legal Secretary for Code Compliance.
You've prepared a statement?
I did. It was a statement that was submitted to risk management after the interactions.
Risk management. Okay, go ahead.
Between Monday, April 24th, 2023, and Friday, April 27th, 2023, Joseph Darmington called our office 22 times. He has spoken to just about everyone in the office. The first time I spoke with him regarding this case was on April 24th. I answered the phone and he asked, I'm going to be cursing.
I need the truth.
Okay. I answered the phone and he asked to speak with the asshole running your division. I asked him to please not curse and transferred him to Director J.C. Charlton. I spoke with him at length the next day, April 25th. He was very angry. I tried to calm him down. He kept interrupting me and getting louder and louder. I tried to explain to him what the special master ordered and even read the order section of the findings of fact. He called me a stupid bitch. I told him I wasn't going to listen to profanity and ended the call. He called right back and Senior Secretary Hope Baird answered. I was standing next to her and she put the phone on speaker. Mr. Darmington told Hope that he's sick of everyone hanging up on him. Hope explained if he would remain civil, people wouldn't hang up on him. She explained he needs to talk to J.C. Charlton in reference to the case because it seemed like it had to go through the director. He yelled, I'm not talking to that black guy anymore. Hope ended the call. He called right back. Hope answered. Mr. Darmington asked to speak with J.C. Charlton's boss. Hope explained that Eric Landon, Growth Management Director, was at the County Commissioners meeting. She offered to transfer him to his secretary. Where was I? I'm sorry. Hope encouraged him to speak with respect to Mr. Landon's secretary. He told Hope, you're just another one of those nasty bitches. Hope hung up. He called back immediately. Hope didn't even say anything. She just transferred him straight to Gina Eason, the secretary. On April 27th, J.C. Charlton and I were at an employee appreciation breakfast. When we got back, we were told by Alan Jonason, Amy Becker, and every other code officer that Mr. Darmington had been calling nonstop. Alan Jonason, Amy Becker, Cody McGuire, and Julie Wilkinson all had to end calls with Mr. Darmington due to his profanity. I tried to speak with him one last time when he called a few minutes later. I again read to him what was contained in the order, and he called me a rude ass bitch, and I ended the call.
Okay. Is that testimony made from personal knowledge?
Absolutely.
Okay. And it's still accurate to the best of your
Yes,
recollection?
Yes, it is.
Okay. All right. Thank you. I appreciate it. I'll note for the record at the last hearing, Mr. Darmington didn't actually deny that he made these statements. He didn't deny that he made insults. He didn't deny that he made racial statements. I had hoped that I'd be able to hear Mr. Darmiento's perspective, or perhaps that he would be able to offer a justification. Part of this is to establish a record. These cases are often, they're very personal. They involve our property, so there's going to be passions on both sides. There's passions on code enforcement side too, because you take your job seriously. But when it comes to people's property, the possibility that there could be a lien or a daily fine or to lose the property in foreclosure is everything. So the one chance you have here is to explain your perspective, and you have a chance at due process. What the county is not obligated to do is to be abused or treated that way. So I'll deny the appeal and just make a finding that that kind of behavior won't be tolerated. There's a room for disagreement, there's a room for passionate disagreement, but that kind of behavior won't be tolerated. Thank you.
Thank you. Next case is on the day's agenda. Angel Monet Rebels, S1 Luis Gonzalez, case numbers 2023-00074 and 2023-00088. Code Officer Cody McGuire. Pages 26 and 27 of your agenda. Expert on the case, Joanna Coutu, Land Development Director.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Can you please state your names?
Angel Monet and S1 Monet.
Thank you.
Cody McGuire.
How you doing? Welcome.
Which one do you want to do first?
Well, let's do the land development code section. Well, the accessory use.
Accessory use?
Yep.
All right. Cody McGuire, Citrus County Code Compliance Officer. Case number 2023-00088. Special requirements for all accessory structures, a violation of Citrus County Land Development Code 3102B. Address is 8533 North Bachelor Button Way, Crystal River, Florida. Property owner Angel Monet Robles and Gonzalez Hezwan Monet. Good service, signed certified member seat and posting at the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during an initial inspection on May 10th, 2023. Photos during a corrective action inspection on May 25th, 2023. And my final inspection conducted on June 20th, 2023. Exhibit B, a copy of the notice of violation, copy of the notice of hearing, and a copy of the signed certified mail receipt.
Before we get into that, haven't we had this code case on this property before?
I think we've had two possibly.
Okay. The same case, correct? I mean,
It had to do with.
different. Okay, all right. Sirs, what I'd like to ask you to do is look through these documents and let me know if you have any objection to them being evidence in this hearing. And as far as I recall, you guys have always dodged the bullets on these these cases. Is there anyone from the public who's going to want to be heard on this case? Okay. I let the record reflect that there's no response. All right, thank you. Go ahead.
On May 10th, 2023, I conducted an initial inspection and observed sheds on the vacant property. During my inspection, the property owner stated that they are living in the sheds. On May 25th, 2023, a corrective action inspection was conducted with no changes. After speaking with the property owner, he stated that he would like to go to special master hearing. As of my final inspection on June 20th, 2023, the property remains in violation.
Is there any other testimony from the county? Ms. Couture, do you?
What's that?
I do. I mean, you're listed
Yes.
as an expert.
Land Development Director Joanna Couture.
Yeah, it's probably more pertinent for the other case. It's CLR 1.1 acres, and they have no abutting property that you could try to talk about.
Well, I mean, this is just, it's residentially zoned, CLR.
Yes, CLR.
And there's no principal structure.
No, not that I'm aware of. I couldn't see anything in the records.
The reason being that these don't qualify as principal structures, or
They're not permitted as residences at this time.
Could they be?
One maybe if they meet Florida Building Code as a resident, sure.
okay, so there's two. You're saying one can be permitted.
Right, you can have a house, you can have a guest house. So theoretically, sure, they might even be able to do two if they meet Florida Building Code and get permits as residential structures.
Okay, all right. Do you all understand the case that the county's bringing? ¿Entiendes?
Yeah, I'm here mainly to translate whatever he wants to say.
Yeah.
A little bit.
Okay. Basically, what the county's saying is that, yes, this is a residential piece of property. And one of the structures that you have on there you might even be able to get it permitted to use as a home. And then you might be able to do some of the other things you want to do on the property. But right now, you can't live on the property when you don't have something that's permitted as a principal structure.
Okay, because we started yesterday to prepare the site.
Okay.
To build the main house. And since the first day that I moved here, I live in this shed, and I request information to help. To what can I do, because I wasting money in rent, just like to use it and buy the construction. Now you can make days for paid impact fees, and I do it, and I start to building the house. I bought materials, and then I'm back on track because of time that when I asked the county, you have 1 year to do that. Okay, when I have the situation, I said, I have this situation. And they said, no, you only have till May 29. And I said, what? You said, May 1 year. Why you changed me the information between them? And the situation here is the time. I don't request money, I don't request help, I just need time.
So you're going to build on this property?
Yeah, it's
so the stuff that you have on the property right now, you're going to move off and you're going to build something?
I read of each of two of them. I have 4. And the third that I have right now, I have this one because that was a recommendation. You have to buy an RV to stay in the site and then go to the building department and add this RV. That the third one that you have in the exhibit.
Well, I think usually it's the other way around. You probably got to get it permitted before you can just put something on a residential piece of property.
I was the same day that I received the recommendation. The same day I stopped here before buy it and leave a letter to Soniva, and then I bought the GRB.
Well, I mean, my recollection is you all have been here before on a very similar case, so I think you understand what has to be done. How much time do you need to either remove these structures from the property or permit or put the principal structure on the property and have it properly permitted?
Okay, but in the permit, the shed are in the permit.
You don't have a permit.
Yeah.
I believe he does have a
It's
permit.
approved.
I think
Yeah.
the last time we were here, they had applied
Yeah.
for a permit, but they did not have the money to pay to
The
pick up the
impact-
permit.
See, this is what I could have sworn we were
And-
here on this
yes,
case.
and then I'm looking at records that show the permit was apparently paid for and issued on
Yes.
November 23rd of 2022.
Because I if I understand, you gave me 1 year for pay the impact fees,
That's right. Okay.
not for the build the house.
All right. I don't understand what's happening
Chris,
in this
I don't
case.
know.
Can I get expert witness Jeff Atkins, certified builder?
Okay. Do you understand my confusion?
Yeah, I
'Cause-
understand.
Okay.
It is confusing.
All right.
Oh, sorry. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you, sir.
Okay. To help with some of the confusion, yes, they applied for a permit. A permit was issued for this residence. That permit has lived out its life of 180 days without any construction. They requested a 30-day extension because of a change of contractor, I believe, is what they stated. That was granted. That 30-day extension is due to expire next month.
Okay.
No work has proceeded, no inspections have been passed, therefore that permit will expire and they will have to reapply.
Do you remember what my order was on this before?
The storage on the vacant.
Yeah.
Yeah, I had that case. I think you gave them a year
I
to
think
come
so
into
too.
compliance. And
When was that case? I mean, honestly, it's relevant. I need to know.
It was in December of 2021.
Is it that long ago?
22. Yes, 2021. They had until January of
they,
2023.
they abated this year for
Okay.
the storage on the
Okay.
vacant.
All right. So you guys did get the permit. You paid for the permit. It was for 6 months. Then you got a 30-day extension, and still nothing's happened. This is a problem. So your case is that, well, if they still have a permit and that abates the instant violation, then don't you have to wait for the expiration of the permit to bring another code case?
Now they're living. This case was for living in the shed. They're living.
It's
in
not just
accessory
having the accessory, it's living in it. Does this make more sense? So you got out of the prior violation because the violation there was just having the accessory structure without the permit for the principal structure and all that. So you have to go through the principal. You got the permit. You did what I asked. But you haven't done anything with the permit. And now you're living there. And that's against the code too, because you're not allowed to live in there without the principal stuff being built.
Okay, the step that was stuck was when I put the first inspection for the temporary pool. The surprise was the work that Duke Energy have to do to my property. They charge a lot, tons of money, and I try to find every neighbor of my street, and someone never appeared, no one answered my letters, and that's why, because I pay all the stuff up to Duke Energy, and I delayed my construction for that.
It's a separate issue.
I know it's a separate issue, but that's the reason that I...
On your prior case, I think I gave you more time than I've ever given anybody else to ever comply with a code enforcement case. I could be wrong. Maybe I've given longer to some, but in the 7 or 6 years I've been doing it, and I doubt code enforcement appreciated that I gave you a year to do it. So I that's a huge amount of time to get things going. I realized that was in a challenging cost environment, and it's still a challenging cost environment. But you can't live there, period. So, I mean, I am going to find that there's a violation. You can't live there while you don't have the principal structure.
Okay, I started yesterday, so I tried to do my best. So
Nothing's going to stop you. I don't know. I can't represent the county, but I mean, you can still try to build and get this thing done, but you can't live there while it's going on. Is there anything else the county wants to?
Yeah, all is not lost, but he can. You mentioned to Suneva. Have you put in a request to have an RV while the permit is active? Okay, so that could allow him to do this while this permit is active. Once it expires, that goes away too.
How long does that last?
That will last for up to 1 year or a CO as long as the permit is active. Whichever is
so you
first.
have a request in for that, and it hasn't been granted or denied. It has been granted.
You have a letter from them saying, okay, I didn't see that in the computer, but not surprising.
that's why the RV.
They can have an RV as long as the permit is active. They can't have sheds to live in, etc.
But that's not the case in front of me. The case is the living inside.
Living inside an RV. Are these RVs? And it is a RV.
They're living in a shed.
They're living in a shed.
Is there an RV on the property?
I use the RV.
I see the RV.
Right, the RV is not the issue.
So I throw it all the stuff that I don't fit in the RV. I go to them.
But
move to
you've
the
testified you're living in the shed.
That was
I
before
lived
the RV.
before the
That was
RV.
before the RV. The money that he was going to use to start the building process, he spent it on the RV. And now we're living in the RV.
You're living in the RV. All right. I am pretty persuaded on this. Okay, so I'm going to dismiss that case, but we still have the animal case, which is case number 2023-00074. So what's going on in that case?
Code Enquirer, Citrus County Code Compliance Officer, case number 2023-00074. Animals in selected land use districts is a violation of section 3730A of the Citrus County Land Development Code. Address is 8533 North Bachelor Button Way, Crush River, Florida. Property owner Angel Manette Robles and
Gonzalez.
Gonzalez.
Okay.
Good service via signed certified mail return receipt and posting of the Canto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during the initial inspection on May 10th, 2023, the corrective action inspection on May 25th, 2023, and photos of my final inspection on June 20th, 2023. And Exhibit B, a copy of the notice of violation, copy of the notice of hearing, and a copy of the signed certified mail return receipt.
All right, sirs, again, I'd like to ask you to take a look at these documents. I'm going to pull up the code section just so that I have it in front of me. Let me know if you have any objection to these documents.
Sorry?
Let me know if you have any objection to these documents. Is there anyone from the public who's going to want to be heard on this case, the animal case? Okay, no response. Thank you. Without objection, what's been proposed as Exhibits A and B are evidence.
On May 10th, 2023, an initial inspection was conducted on the property for ducks and emu, geese, and chickens on this vacant property. The property was found to be in violation of the above
Can you repeat
ordinance.
that? Ducks, emu,
Geese, and chickens.
chickens. Okay.
The property was found to be in violation of the above ordinance. When speaking to Mr. Monette, he was advised that this was a violation. The property remained in violation at my corrective action inspection on May 25th, 2023, as well as my pre-hearing inspection conducted on June 20th, 2023.
Okay, I'm just going to look through the code section real quick. How big is the parcel?
1.1 acres.
Yes. It's CLR.
All right, so what's the violation?
Animals on vacant property.
What animals are the violation?
The ducks, the geese, the emu.
All of them are violations?
On vacant property, yes.
Is it possible, so what the county's saying is that they'd have to get rid of all the animals until the principal structure is established?
Trying to continue land development. Partially. The chickens up to 10, hens only. You can see that as personal pets outside the residence. That could work. Possibly the emu. Even the ducks, the geese are actually prohibited. Those aren't going to allow, period. They don't have enough acreage to fall into the animal schedule for those other animals. But once they get a house, they can have some chickens. They can have the ducks. And the emu's not listed as prohibited. So possibly.
So if they had the house, they could have all of them?
No, not the geese.
Not the geese.
And up to 10 chickens, hens only. I don't know if these are or not. They are limited. There's a section, you've got it pulled up there, but it's personal pets outside the residence, which is after the animal schedule, because I can't qualify for that due to the size. So there's some animals that could be there once a house is there as personal pets.
So what if is it possible to get a permit that allows them as part of like their principal structure?
No.
No.
No, it falls under the animal schedule, and there's not a variance or anything for that. So they don't meet the 2 acres, so that wipes out that whole animal schedule. Personal pets outside of a existing residence, the 10 chickens, the ducks, not the geese.
But as long as it's vacant, they're all in violation.
Correct. Until they get a house there, they can have some of those personal pets.
Does this make sense?
Yes, makes sense. But the reason why that I had the geese and the emu, I explained the code is the reason why, because
Whose phone is that? Is it? Okay.
because the emu is my bodyguard and the geese is my alarm. I have in my property twice the vandalism and 1 car killed. So, que te robaron.
Oh, stolen car.
Yeah.
So I need something to help me to verify by sound or something like that, and he knows I prove it to him. But I know
You might see if the county will consider landmines or something like that. I don't know, but animals.
Yeah, I read up because
I think it's sad because these are beautiful
it's sad.
animals. I wish I had them.
and I bring them to the man who doing the job yesterday at home.
Well, maybe you have some other property where they're allowed to be. I don't know.
Because I'm always have the situation, because if I put something, someone call and place the.
Well, sir, I get it. I mean, it's just I can't do anything. The code says what it says. So how much time do you need to?
I just wait for him to, because I tell him you have to make a cage for keep the animals. That's all. So.
How much time do you need?
I have to talk with him because I think in the same month, I think he.
So you think 30 to 60 days?
Yeah.
Okay. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assesses a fine of $150 per day along with administrative costs to begin after the day you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is given to the severity of the violation and the respondent's actions relative to this violation. We would also ask the special master additionally to find that it's a respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for a reinspection.
I'll find that the property is in violation and grant 60 days from today to abate the violation. If the violation is, I'm sorry?
I have a question before.
Hold on. If the violation is not brought in compliance as ordered, a penalty of $50 per day will be imposed. This fine will be recorded and constitute a lien on the real or personal property of the owners. What's your question?
My question is, what the difference between December 9, 2021 from the same situation like today, and it says no action necessary, and I have the same emu and the same geese and the same chicken as back on December. What the difference today?
I have no idea. Was there a prior case on the animals?
And the system shows no action necessary. So
I don't know.
I just have the question.
Yeah. I don't know. I don't remember having this case before. I mean, did I rule on that? Did I say there was no violation?
No.
All right. So this is a hearing in front of me, and I'm making the determination that it is a violation of the code. It's extremely clear. But you do have the right to appeal the order if you want. So.
Yeah, I want to, because what the difference between December to June?
Yeah. All right. I think you have 20 or 30 days to appeal the order, but I'll write it out and issue it. Okay? All right. Thank you.
Next case on today's agenda, Wayne Wilkinson, case number 2023-00015, Code Officer Amy Becker, page 36 of your agenda.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Can you please state your name for the record?
Wayne Wilkinson.
Thank you, sir.
Good morning.
Good morning.
Good morning.
Good morning.
This is case number CE 2023-00015, accumulation of junk and debris, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 3, Section 20-31A. This is a repeat violation. The property owner had been previously adjudicated guilty of the same violation at the same location on July 20th, 2022, case 2163698. The violation abated on August 19th, 2022. No fines were imposed. The address is 3 West Lemon Street, Beverly Hills, Florida. The property owner is Wayne Wilkinson. I have good service via posting of the property as well as the Lecanto Government Building and a certified mail return receipt. I would like to authenticate the following documents and request that they be admitted to evidence. Exhibit A, photos taken during my initial inspection on May 2nd, 2023, photos taken on May 5th, showing the posting of the property, and subsequent inspections on May 9th, May 12th, May 19th, June 2nd, June 6th, June 9th, June 14th, June 16th, and photos taken on my final inspection, June 20th, 2023. Exhibit B, a copy of the administrative complaint and notice of hearing for the repeat violation, a copy of the posting affidavit, and a copy of the certified mail return receipt, signed for on May 11th, 2023. Exhibit C, a copy of the findings of fact and the order acknowledging compliance for the previous violation.
Sir, I'd like to ask you to take a look at these documents and just let me know if you have any objection to them being evidence in this hearing. Is there anyone from the public who's going to want to be heard on this case? Just so everyone knows, we've gone through about 25% of the hearing docket so far. So I think we'll take a 5-minute break after this case.
Are these all considered to be violations, or
They're all
in every picture?
They're all evident. Yeah, I think that's what the county's providing. We just-
Actually, the photos also show when he's been in compliance.
So the
he
property-
came into compliance and then he went out of compliance.
During the
so
period-
there's pictures in there of when he's in compliance. I tried to give you a.
So in the period from May 2nd to June 20th, there's photos where the property's in compliance and there's photos where he's out of compliance.
To be specific, May 5th through June 5th, he was in violation.
Okay.
And then June 16th through June 20th, he was in violation. And the period in between, he was in compliance. So that would be June 6th. I found the property to be in compliance. So I included those pictures so you could see.
That makes sense. The relevance is that for the days that you're not in compliance, the law requires that I impose a fine.
Well, on a lot of these, I wouldn't know what's in compliance or isn't in compliance.
All right, we can talk about it.
And these are just the other exhibits. So if you want to look through those, these are the photos. Thank you. Is this everything? Yes, sir.
Okay. Then without objection, what's been proposed as exhibits A, B, and C are evidence. We'll talk about them. Go ahead, Ms. Becker.
Okay, so on May 2nd, I conducted the initial inspection for the accumulation of junk and debris, and I observed furniture and trash not contained, which is a clear violation of the ordinance listed above. I called Wayne Wilkinson and left a voice message advising his property was in violation. I posted the property on May 5th with a notice of hearing for the repeat violation. And I contacted Wayne again on May 3rd. So he was aware of the violation. And then again, as we've discussed, as far as the violation, it came into compliance on May 6th and then came out of compliance on this June 16th.
Are the pallets considered junk?
Which picture, what date are you looking at?
May 5th.
No, actually, he said he was going to use those.
Okay.
So.
So I assume the vegetative matter is a part of the county's case?
Affirmative.
On June 2nd, are the ladders on the ground a part of the county's case?
They're usable. There's trash.
So the answer is no.
Correct.
Or negative?
Negative.
What are the dates of non-compliance again?
The non-compliance dates are May 5th through June 5th and June 16th through June 20th.
In other words, as of your last inspection, the property is in compliance.
As of my last inspection, it's in violation.
Oh, so as of today?
So as of today,
okay.
as of yesterday, it was in violation.
Okay.
And when I was there, Friday, the owner was there, and the pile of vegetative matter was discussed. There was a gentleman standing next to him, and he said, "I'll have it removed as soon as possible." When I inspected on Tuesday, yesterday, there's trash that's not contained, and the pile of vegetative matter is still there.
Can I ask you to come up and look at the photo, page 15 of 34, June 2nd? I'm trying to understand what the violation is.
June 2nd was the furniture. We have a trailer of furniture there on the 2nd. I was just trying to give you at least 3 shots per day to try to give you an idea of the property because it constantly changes. So the furniture, the discarded furniture in the trailer would be a violation. And there's also some debris on the ground.
Was the trailer moved? I mean, has that...
It was, in other words, it's changing. So that was there that day that I was there.
Mr. Wilkinson, so on June 2nd, there's a photo of furniture on a trailer. How quickly was that trailer removed from the property?
The whole property has been in constant transition since I've owned it because of confusion over the code, over the zoning of the property.
The zoning?
Yeah. I'd like to read a letter if I could.
Well, let me ask, I just need to understand what the county's saying before I get to...
If there was furniture on a trailer, we were probably hauling it away.
Yeah.
I can't, without looking at the photo, I'm not sure.
Yeah, I mean.
Can I look at that photo again?
Yeah.
Specific?
Yeah, come up. No, it's okay. He can do it. So this is page 16 of 34. This is their violation, which is that there's furniture in a trailer on the front yard.
Right, actually what we were doing was emptying this awning or carport or whatever out to take it to the
Correct. How fast did that trailer leave the property?
Well, no more than days. It might have been that day. I can't remember.
Okay.
I don't know. I use volunteers. I operate first.
I mean,
first door.
Ms. Becker, if the trailer left on June 2nd, and you see it all piled and strapped in there, they're trying to bring the property in compliance. Is it a violation if they put it on the trailer and brought it out that day?
When it's a repeat violation, I have to check twice a week.
Yes.
I would consider it a violation to have a trailer full of discarded furniture. I would consider that a violation.
If they're storing it. But if
They
they're...
can't store it in a trailer on a property.
I know, I agree. But if they're moving it off the property...
Again, it's a repeat, so I don't have the easiness of saying, okay, I'll come back tomorrow.
Okay.
In other words, the owner has been advised numerous times of what the ordinance and how the ordinance reads. This is not a surprise.
Well, that's true, but if it's unrebutted testimony that they moved the trailer that day or the next day, then it wouldn't necessarily be the case that it's out of... I'm just telling you my thought process.
Right. No, I get it.
Okay. I would like to hear from you then, sir. Go ahead.
Yeah, if I could read this, please.
Yeah.
My name is Wayne Wilkinson. I'm pastor of Living Water Ministries of Citrus County Incorporated. I'm also the president. Gloria is with me. She's one of our board members. When we were here the last time to ascertain stipulations would satisfy a complaint against a property that I own, a property that I only purchased for use by Living Water Ministries as a thrift store. Excuse me. We've been using profits from our thrift stores to pay church expenses and to help needy people in the community. I purchased the property because I understood it to be zoned commercial. In fact, the sales contract said it was commercial, guaranteed it was commercial. In fact, information shown by Citrus County Property Appraiser's Office, which I believe is part of Citrus County government, says it is commercial, agricultural, and sales. Some of this might not seem pertinent. I'm going to go fairly quickly.
I'll let you be heard.
Other Citrus County documents agree. And by the way, commercial, agricultural, and sales. The original complaint brought further scrutiny by code enforcement, including first to a shipping container, which, knowing the property was commercial, was not an issue. That later was removed to satisfy that part of the complaint. We agreed to comply to all counts. Not being in tune with the system and with my verbal inquiries unanswered, I later realized the complaint was illegal complaint. This because the complaint was made by a county official rather than a private individual. One of the things I was requested to do was to file for a conditional use permit. This would have been admitting that this was indeed residential, though it is not. I also came prepared to file for that at the initial hearing. What was told at the window in the office outside that it would cost me $40,000 for improvements to make the, in order to get the conditional use through. It also would have been admitting that it was residential, which I believe it was not. So I had an application with me, but I never turned it in because I couldn't afford to do that. We felt we should try to later solve this problem, so we delayed following the orders from the previous hearing. Later, however, we realized it would cost a considerable amount of money to hire an attorney. Furthermore, this property includes mailing addresses of the original two lots, number 1 West Lemon and number 3 West Lemon. These properties were merged partly, I assume, because the property line runs through the corner of the building on number 3. This property was used as commercial consistently, numbers 1 and 3, consistently as commercial, many times over the years, almost never as residential. Yet I've now been forced to rent the property and have rented it to a family with babies. This literally could be the only property on Route 491 in Beverly Hills to have children playing by the highway along this section where it is already 4 lanes. Part of this is, concerning drunken debris. Personally, I was overwhelmed at this time finding that the building, as we started bringing things to the location for a thrift store, out of storage, that we realistically couldn't bring it into the building as it needed more work than I had realized. So there was a mess in the beginning. As I worked through the issues, it took longer as I was pressured to get this done, first for the purpose of a thrift store, followed by having to convert it to residential. I believe I was unreasonably refused clearance of this complaint. One day, because there was a sofa left there upside down in the front yard and the tools there for me to take it apart so I could put it on the trailer to take to the landfill. That reasoning was disregarded. Also, because there were 3 cinder blocks that were located by the stop sign, county property, and I know they were there from years from the decorative wall that was torn down years earlier. This complaint is now renewed and clearance for the complaint was refused. One time because the resident had his barbells by the outside of the house against the wall where he actually was using them. There were also 2 cinder blocks, and that's in the one photo, by the back corner. That's all that was mentioned to me at that. In that photo, there is some vegetation, but that wasn't mentioned to me. This most recent, the back building of the house, all keeping the complaint open. This most recent complaint open. Apparently there was a threat of a complaint actually being kept open also because the renter had a washing machine by the front door, which he was using to replace the one in the house. He had not had time after one day because he was working to get it into the house. When I first produced the property, that's not in the photo, but when I first procured the property, someone came out from the property appraiser's office. I walked around the house with them and signed a paper agreeing to what was said on it regarding the zoning being commercial. And I have a copy of that here, but this is a newer copy that I did not sign.
Let me ask you this. What is the relevance of whether the property is commercial or residential for whether there's junk?
Well, because I was forced to be in constant transition with this property. One of the things was I had a container, one of the complaints. Once the complaint was opened, then it opened all kinds of things. I had a container by the road. That was commercial property. You're allowed to have that. I put a fence up in front of it. Finally, I caved and got rid of it.
I don't think any of that
is...
is...
It's just one thing after another after another is my point.
I don't think any... So, but you're not claiming that if the property is... Let me ask you, are you claiming that if the property is commercial, that you're exempt from complying with the section 20-31A?
The drunken debris?
Yeah.
No, I'm not.
Okay.
No, I'm not. But I'm trying to explain
part of
the reasoning and part of why this went on and on and on. And some of the things that we cleared up, for example, where there was, I don't even know if it was on there. There was somebody in the past before I had the property had built like a little shanty out of pallets on the back corner of the building. And when we took that down, it exposed some other vegetation and things, and we had to cut down more vegetation. So all of that was process. Mm-hmm. It was constantly process of us cleaning it up. But this was the initiation of all of this had to do with whether it was commercial. And this is what just kept me off keel. And we use only volunteers. So unless I do it myself, I have to try to get the volunteers together to do it. Now, the county says, the zoning department says that what the property appraisers say doesn't matter, that only what they say is what matters. But yet, I don't understand how the county can be in contradiction of itself over some of these things like the zoning. And this form, I signed a form saying they came out from property appraisers and I walked with the young lady around the property when I first obtained the property, and the form was saying that it was commercial, agricultural, and sales. And on the back of that form, I signed verifying that zoning. Okay. Now, after that, they sent me another form where they stamped in with a little 3-letter stamp. It still says that on both sides. That is commercial, agricultural, and sales, a verification request. But they stamped in with 3 little, it looks like something from 2nd grade stamp that you'd slide the letters in. It says MDR. So, just all I'm saying, Your Honor, is that it's been just constant conflict with this. And once attention was brought to it by a county commissioner, it's just been constant of ups and downs and me not able to keep up with it because I don't know really constantly what's next.
Well, let me.
So and my bottom line, let me just finish one thing. I do want to say that I would like to put all this behind us and we will comply.
Right.
Okay. But at the same time, I feel like some explanation is in order, and I'm certainly not done with someday pursuing this as commercial property.
Right. Yeah, I mean, as a first matter, I don't find that whether it's commercial or not bears on whether the code section applies, but I do understand the point of what you're telling me.
And we're putting a fence up too.
Well, it looks like you've already put.
We're putting a fence up around the whole thing
yeah.
as we speak. Part of it's up, and the fencing is there.
And the property looks a lot better now than it did at the beginning. I do agree that on May 2nd that there was a violation. I agree that in other words, I understand the reason for it being there, but the code is the way that it is. You can't have this stuff in unenclosed receptacles and things. It can't stay there. So as a technical matter, I agree that on May 2nd, there was a violation. I agree that on May 5th, there was a violation. I understand why it's there. I don't find that
one by one, we were taking care of them.
Correct. And I don't find that the pallets are a violation, but it's mostly debris that's junk that's under the overhang. That's really what I find to be the violation on that day. And then going to May 12th, things are substantially improved on May 12th. I do see the cinder blocks.
And I didn't even include the cinder blocks. Let me just state that.
Okay,
because
good. Because I don't find that that's a violation.
And let me clarify.
Yeah.
He has my cell number. He has my contact information. Right. He can call me anytime he wants to come out and do an inspection. So May 12th.
I'm not quite done yet. So on page 12 of May 12th, I do see that there are branches and some limbs that qualify as vegetative matter under the code. I see no other violations on May 12th. But Mr. Wilkinson, do you know the group of branches that are in, I guess, the side or backyard on May 12th? Do you know what can you come up here and look at these branches? Sure. How long?
Actually, we were asked to clean that, to cut the brush in the back. And that's why it was like that.
When did you cut it?
Right before that.
Okay, and how long was it there on the ground?
I really don't know.
I mean, do you know when you took these branches out of there?
The young man that lives there, I bought him a chipper, and he's supposed to be cutting it down and then chipping it.
Okay, so you don't know when these branches actually left. Ms. Becker, do you know when these branches left? I mean, because
I'd have to look at the pictures, but
Mr. Wilkinson, hold on. I'm talking to Ms. Becker.
I'd have to look at the pictures again as far as dates, but because on the 12th it was the vegetative matter, but there was also an appliance in the back. And then that pile of vegetative matter, and that was on May 12th.
What's the appliance on May 12th? What's the appliance?
It looks like it's like a humidifier or an AC. I don't know what it actually is, but it's something that would be intent for inside.
Okay, well, let me ask Mr. Wilkinson. I mean, because we're on a day-by-day analysis of whether there's a violation, I have to go through it. What is that device? I agree, it looks like some kind of a humidifier.
It's an air filter.
It's an air filter.
Air cleaner.
Were you using it at that time? Do you know where this piece of equipment came from and how long it was there?
I don't know how long it was there. The picture of the front of that carport being open, that awning being open, the only time that was open was when we were cleaning it.
I'm only asking about this appliance.
I'm not familiar with.
Okay, so you don't know.
I
All
don't
right.
really reckon. I can tell you what it is. I don't really.
Okay, all right. And then on, let's see. So, okay, so then on May 19th, Mr. Wilkinson, you can return to the podium if you would. It appears that device is still there. I think that lends evidence to the county's position on it, because it's probably getting rained on. The vegetative matter is still there. I'm now on June 2nd, where there is a picture of ladders, and
It would be the furniture in the trailer too on the second. So
okay. Well, I don't, that's a tough one. So Mr. Wilkinson, you don't live there, correct?
No, I do not.
Okay, who does live there?
A young man that I know, he has a wife and 2 babies.
Okay.
Her dad, I know Miss Becker has spoken to her dad on occasion. He's there sometimes. He's actually moving out of state.
I don't find that the trailer is a violation on June 2nd, but I do find that there is debris, there is junk that's still there on June 2nd. On June 6th, the property is in compliance, and
Yes,
that
sir.
lasts until June 16th. Yep, it looks great on June 6th, looks great on June 9th. Obviously doing a huge amount of work, looks good on June 14th. Garbage cans look good. And then the violation on June 16th is the branches.
the June 16th is the pile of vegetative matter.
Mr. Wilkinson, and you have to look at this. On June 16th, there's a pile of vegetative matter. Do you know how long this vegetative matter was there?
Not a real long time. Again, that was from the back being cleaned up. I don't know.
It was there on June
He's supposed to-
20th.
He's supposed to chip
It was
that.
still there.
June 20th, it was still there.
I was supposed to chip that. And frankly, at that point, I was
And then on June 20th, too, there's...
contracted somebody to put fencing up. for
And then
it.
on June 20th, there's junk in the front yard. So it's not just it's the vegetative stuff that's still there. If it was there for 1 day, I would not find that it's a violation. If it was there for 2 days, I would not find that it's a violation.
It wasn't there.
Technically, it is a violation. So, although I've looked through all the photos, I believe that the county has proved its case. In other words, that there are violations on the dates that Ms. Becker says there were. So what's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $150 per day, along with administrative costs, to begin May 5th, 2023, and continue to June 5th, 2023. That would be 32 days at $150, totaling $4,800. The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $150 per day, along with administrative costs, to begin on June 16th, 2023, and continue until June 20th, 2023. That would be 5 days at $150, totaling $750, and a fine of $200 per day from this day forward until the violation is abated. We would also ask that the special master find that it's the respondent's responsibility to notify the Code Compliance Division when the violation has been abated, so that we may re-inspect the property.
The first period where it's out of violation was 32 days according to your calculations. What was the second? 5 days?
It's 5 days, June 16th through June 20th, 5 days.
Well, Mr. Wilkinson, what I have to say about the property is it's clear that you guys have tried to improve. It's clear that there's massive improvement. It's also clear that there's a technical violation on each of the days that the county said. And it's really important that y'all keep the property clean because these fines are going to continue to happen if either you or the tenant doesn't take action to keep the junk out of the front yard, out of the side yard, and just keep it clean. I encourage you to remain in contact with Ms. Becker to get her input on it. In the meantime, I am going to find that there was a violation from May 5th through June 5th. Is that right?
May 5th through June 5th.
That's 32 days?
32 days.
Oh, because it was... Okay, correct. And then from June 16th through June 20th of 5 days, I'll assess a fine of $50 per day, not $150 per day, for a total fine of $1,850 instead of $5,050. But it will be $150 per day going forward, so it's very important to fix it. That's it. Thanks.
Christian?
Yeah.
I'm sorry, can you clarify? $50 a day for the first 2 periods?
Correct.
Thank you.
Yep. Thank you.
Thank you.
Next case on today's agenda, Pizza of Florida Incorporated, case number 218-6069, Code Officer Julie Wilkinson. Page 23 of your agenda, Joanna Coutu, expert witness on the case.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I did.
Can you please state your name for the record?
Anthony Fotopoulos.
Welcome.
Thank you.
Please proceed.
Julie Wilkinson, Citrus County Code Compliance Officer, case number 218-6069, a violation of Citrus County Land Development Code, Section 4002, site development without a development order or permit. The address is 7105 West Cardinal Street in Homosassa, Florida. Property owner, Pizza of Florida Incorporated, or Inc. Good service via posting the notice of hearing on the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, a photo I took during my initial inspection on March 27th, 2023. Photos of a subsequent inspection on April 3rd, 2023. Photos of my final inspection on June 20th, 2023. And an aerial photo taken from the property appraiser's website. Exhibit B, a copy of the notice of violation, a notice of hearing, and a copy of the posting affidavit and photos of the notice of hearing posted on the property.
So, sir, you've probably seen us go through some of these.
Sure.
Could you just take a look at the documents?
Yeah, absolutely.
Let me know if you have any objection.
I'm not going to contest what she's saying about the clean out of the property.
Okay.
So.
All right. Is there anyone from the public who's going to want to be heard on this case? I don't see
think
anybody.
So. I seriously doubt it. This was more about cleaning up more than basically we should have been.
Okay.
But I also have my reasoning for doing it as well. So, but yeah, I'm not contesting any of that. Okay.
Bless you. Thank you. Without objection, it's been proposed as exhibits A and B are evidence. Go ahead.
I conducted my initial inspection on March 27th, 2023, and observed that the property had numerous trees removed. While researching the property, I observed that there were no permits applied for or issued, and the aerial photos from the property appraisal summary depicts a large amount of tree cover on the property before trees were removed. I have had contact with the property owner who stated he has no intentions to develop the property at this time. As of my final inspection on June 20th, 2023, a permit has not been applied for.
Okay. Is there anyone else who wishes to testify from the county?
This is a general commercial zoning. We actually got calls from the public and the newspaper. What's going here? It does look like something's being prepped for development, but we have no permits,
Okay.
no applications.
All
Okay,
right.
yeah, just, you know, we're actually, the process of what we were going through is a reaction to some nuance or nuisance that we've had, right? So if you guys know that the gas station's right there, we had a fence with a gate, which has been destroyed. A lot of the overgrowth, when my dad bought that property, it was a trailer park, right? So a lot of this was overgrowth, and it was creating cover for homeless people. So now we had a ton of stuff to be dumped, and basically we needed to clean the property up again. And we wanted to remove the overgrowth that started to cover where we had no idea where concrete slabs are, because we just kind of bought it, you know, and it was already, I think, closed. So, and then the other part was just for liability, you know, with the homeless guys going back there and people dumping stuff. Insurance companies are giving us a hard time about anything. And they would come and inspect, and then, you know.
Do you
so
understand
I don't
what
know how
has to
else
be done to kind of like fix the issue? I mean, they say you need a permit or.
Well, so I don't have, our intent was not to build anything right now. Our intent is to clean, maintain, you know, and keep liability at a minimum.
Is it possible to get a site clearing permit? No, it has to be in connection with. So they can't do site clearing unless it's in connection with actual construction.
Active construction.
Is it still considered vacant land, even though it was already previously used as a mobile home park that has concrete slabs? I mean, a lot of the
Well, it's
clearing
irrelevant.
out.
Yeah, I mean, you can't do
mean,
site clearing without a permit.
So you got to pull a permit every time, even for overgrowth. I only ask the question because I can't. You know,
so here's the code section. It says no development allowed by this code shall be established, changed, or altered. I mean, let's look. I mean, I'm looking at it not to, and no building shall be used, occupied, or altered. So that's not the issue.
No.
It's really the issue of no development allowed by this code shall be established, changed, or altered until there is first on file, approved by official county action, a site development plan or subdivision plat for such premises. Nothing herein shall relieve any applicant of the additional responsibility of seeking all permits required, et cetera, et cetera. A site development plan shall be required for any development on vacant land. Site development plans may be submitted for any portion of the site, including early work author or for site work, provided development proceeds according to an approved plan. So this is more like a case where someone cuts down a tree when they don't have permission.
I understand, right? Yeah. And like I said, everything is for us to limit liability, you know, for the property sitting there.
I understand why you did
right. And it's not, you know, this is, you know, we've had boats dumped there. We got rusty stuff. They were doing fires back in the back of the property, which with no building, no running water.
Right.
I mean, we're trying to just limit our liability. So
well, it is surprising to me that you can't get a site clearing permit without construction.
Right.
But that's the way it is. Let's see.
So, I mean, and basically what I was looking for is just tell me how to rectify it. You know, give me some time. Let me know what I can do. But also just something that doesn't, you know, like I need it to be unenticing to homeless and people to go hang out in the property. You know, from what you guys can gather with the name of our corporation, we're in restaurant business. So any aspirations of expansion that, you know, back when we bought this property changed during COVID, so.
Is there a kind of a permit where you could do site clearing for like putting a bench there or something like that? I mean, something that's like minimally.
You'd have to be establishing a primary use, and you know you can't just put it for a shed or a bench. No, and you know if you were building a park, perhaps.
Right. What's the zoning on this? It's
GNC. It is general commercial. He's familiar with that. I know when I was out there last week, the fence is crushed in, and so they certainly can secure the fence.
Yeah,
but the clearing is the problem.
Our intention is to do. We're going to fix it all up. You know, finish completing the process of putting a new fence. But like I say, for me, it was more about a deterrent.
Sir, you made that abundantly clear on the record, and you've also made it clear about the limitation of liability and what you seek to do on the property. I assure you, I understand all of that.
Right.
But I can't find a code section where what y'all did is permitted per se. But what are the only ways of abating this to get a permit?
Correct. This is irreparable damage kind of thing. I mean, getting a principal structure could allow then recognition of, well, not the clear cut. They'll have to establish some more trees. But yeah, there's no way to get an after the fact permit for this clearing.
Does the code authorize a one-time fine?
Yes. Oh, I'm not an attorney.
In the past, I know the county has done that instead of one that accrues every day.
And I think that's what she's recommending.
We can,
okay.
We can do a one-time fine.
Well, I'm just curious. I'm not trying to tell you what to do.
And
What
obviously, you know, our intent is to accommodate and
yeah,
the area nice. I mean,
no one's accusing you of trying to harm the public interest. What is the county's recommendation?
Due to the irreversible nature of this violation, the Citrus County Code Compliance Division respectfully requests that the special master assess a one-time fine of $2,000 along with the administrative costs. This amount was selected based on the actions of the property owners once they were advised of the violation. We would also ask the special master to additionally find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
Well, I don't think that'll be necessary. I do find that consistent with prior cases where it's irreparable. I think it's a better result than putting a daily fine because they can't comply with it. So that's what I'll do. I'll find that the property's in violation, assess a one-time fine of $2,000, and that'll be reduced. I mean, it's just got to be paid. And there is no finding of bad faith or anything like that. We understand how it happened, and frankly, it happens fairly often.
Yeah, and it's just, you know, we're not, you know, near the property every day. So, you know, nobody's calling to say, hey, there's guys going back there. And, you know, I mean, I didn't want to put my hands in anything over there. So a lot of the clearing was done by big equipment. And, you know,
well, that's it.
We still got a process, you know. So.
We appreciate that. All right. Well, thank you
I appreciate
very much.
you guys.
Yeah.
Thank you.
Next case on the day's agenda, Josephine Richard.
So you'll send paperwork to
I'll issue an
finalize all
order.
that? So there's nothing I do now?
Correct.
All right. Thank you, guys.
Next case on today's agenda, Josephine, Richard, Diana, Chris, and Edward Selman, case number 218-5478, Code Officer Julie Wilkinson, page 31 of your agenda.
No, I do need to take a little bit of a break. Okay. I meant to do it on the last case. I will say that I think what we're looking at is a lunchtime of 12:30, a break. I mean, we're 33 to 40% of the way through this thing. So what I'd like to do is go into, the time is 11:12. Let's be back at 11:17. All right, the time is 11:19, and I'm actually 2 minutes late calling this hearing back to order. And so we'll now hear from the county, I guess. Okay. Well, we're going.
We're going?
Yep.
Oh. All right. Julie Wilkinson, Citrus County Code Compliance Officer, case number 218-5478. Address is 5170 Shady Oak Avenue, Lecanto, Florida. Property owner is Selman Josephine, Selman Richard, Selman Diana, Selman Edward, and Selman Chris. I have good service via posting the notice of hearing on the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, a photo taken during my initial inspection on March 27, 2023. A photo taken during a corrective action inspection on May 11th, 2023. And a photo of my final inspection conducted on June 20th, 2023. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, copy of the notice of hearing posted on the property, and a copy of the posting affidavit.
Are the Selmans here?
Yeah, they were at this podium earlier.
Amy went to go grab them.
All right, then I'll reserve ruling on their admission, but I'll let the county take a look at the exhibits. Is there anyone from the public who's going to want to be heard on this case? All right, no response.
Mm-hmm.
The truck cases are always interesting.
This one's gonna.
Oh, really? Okay.
There actually is someone from the public.
Okay, no, that's fine. All right, I mean, as long as you know. Okay, let the record reflect that there is someone from the public in or around the government building that may want to be heard. They're not here. We gave 5 minutes, it's been 10. Anyways, go ahead. I'm going to reserve ruling on the admission of the exhibits till the respondents can be here and look at the documents. Okay?
On March 27th, 2023, I conducted an initial inspection and observed the property to be in violation. On March 27th, 2023, a notice of violation was issued for trucks parked in a selected land use districts, which is a violation of the ordinance listed above. On May 11th, 2023, a corrective action inspection was conducted with no change to the property. I have had contact with the property owner as of my final As of my final inspection on June 20th, 2023, the property was in compliance. Though the property has come into compliance, this case is brought to the special master hearing due to the history of complaints and numerous violations of the same land development code. To date, there have been 3 cases and 1 citation issued between 2022 and 2023 for violations of the same land development code.
So what you're saying is that there's been multiple investigations on the property for the same thing, and it's never come to my attention, but code enforcement's dealt with it a couple times.
Yes.
3 or 4 times.
Yes.
Okay. My understanding of the code enforcement laws is that even if the property has been brought into compliance by the time of a hearing, if by the preponderance of the evidence there was a violation, that I can still find that there was a violation. There's just no fine. And I can't find a fine because they've already brought it into compliance. But such a finding could be the basis for a repeat violation in the future. Is that the county's understanding? And is that what the county is asking me to do?
Yes.
And who are you looking to for guidance when you give me those answers?
My coworkers.
Okay, who are they?
Lori, the legal secretary.
Okay. Does anyone from the county, I mean, I'm not trying to be hard. I'm just trying to understand what the county wants.
No, due to the nature of this violation, we've had it numerous times. I had it for a citation.
On a prior case?
Yeah, and explained the violation. The truck keeps coming and then it's going. We're actually going to do a one-time fine just for the day that it was out of compliance, that it was there. That's what we're.
Oh, that's what you want?
Yes.
You want a one-time fine for the violation, even though there's never been.
For the day that it was.
Even though there's never been a finding of a violation before?
For the day that it was out of compliance with the truck being there, and then on the corrective action inspection when they were noticed of the violation through the notice of violation.
I see what you're saying. Okay, so I'm going to think about that, and what I'm going to do is I will read the code section because I don't think this has ever been brought in front of me before. Ms. Wilkinson, what's the size of the lot?
The size of the lot is 4.75 acres.
Okay. 4.75 acres.
I apologize, I missed you opening this up. I can't testify on this
Yeah,
particular
by all
item.
means.
It is a residential lot, 4.7 RUR, rural residential. It's less than the 5 acres that would qualify for the conditional use.
Right. So, okay, I see that the minimum lot size shall be
Right.
greater than 5 acres.
And so past truck parking.
So none of these trucks are allowed.
Right, they cannot have a truck parked there at all. There's no condition, the conditional use option is not there. It's rural residential. He's argued with me quite a bit about loading and unloading. That's not even part of the RUR section, honestly. That says
Right.
conditional use only.
Right.
So even if we went there,
And that's 3320A.
yeah.
Yeah.
And that doesn't even mention RUR, honestly. But I told him I'd need to see some unloading and loading actively, not just self-declaring that. Even so, but it's RUR, so that even that's not applicable.
Well, let me take a look. I mean, I just want to be able to understand because I've never seen this code section before. Where is the section that says trucks can't be parked in an RUR?
I think it's because.
It doesn't say it can't be parked. It's the next section. It talks about the conditional use available to the RUR.
I know, but it doesn't prohibit.
Yeah, I believe that 3320 only allows trucks to be in specifically designated land designations to load or unload. So it's not even permitted to be in the RUR to load or unload because RUR is not listed in 3320A.
And there's a following section that lists the sections the zoning districts they are allowed in.
I want to just go through each code section just so you see my thought process. In 3320A, what it does say is trucks shall not be parked, stopped, or allowed to stand at certain areas except unless it's for certain things. But the fact that RUR is not mentioned actually is not really relevant for the county on this because it doesn't. It's saying that they shall not be parked in those sites. It doesn't say shall not be parked, stopped, or allowed in RUR. So I'm not even looking at that section. It's not relevant for or against the county's case. And then in subsection B, trucks as defined by this LDC shall be allowed as a conditional use within blank blank RUR, subject to the following criteria. And then it says in C, trucks as defined by this LDC shall be allowed in the following districts, which seems to give a general permission for trucks to be in CLC, AGR, that kind of thing. I'm not trying to make your lives difficult. My problem with the way this is written is that it should have a general prohibition. It should say trucks are not allowed except as stated in 3320A, 3320B, but it doesn't say that. All it says is trucks as defined by this LDC shall be allowed as a conditional use. It doesn't say that they're not otherwise prohibited. I know what it's implying.
Right, I think that the listing of the following zoning district listing, it definitely says that. I think by saying it's allowed in this, this, and this, and RUR is not listed.
I know what it implies. I agree.
Yeah, I don't even know if it's implied.
It's,
I'm not an attorney, but I know it's not implied. But I think because of that, it pretty much rules out the idea of RUR being allowed.
well, we're supposed to read these things called in peri materia, which means together. You know, I can't ignore one section to the exclusion of the others, but it's not pretty. So that's not, I hope you understand. So anyways, I agree with the county on this. I do agree that based on reading all these code sections together, it seems pretty clear that the only way you can have it in an RUR is under these conditions. And that's with, I mean, they still got to get the conditional use approved. So,
Right, and I know in prior truck parking cases, what we've looked for, because we know they come and go, is looking for a guilty verdict because we expect it will probably show up again. He's told me in no uncertain terms he has no intention of moving it.
it makes sense.
He said he has no intention of applying for conditional use because that costs money. He can't qualify anyway. And he has told me multiple occasions, I'm not moving it.
It makes sense. So let me look at the photos. Can you guess what I want to look at next?
Truck definition.
Definition.
It's there.
Truck definition. I'm trying to find it.
1,500.
1,500. Thank you. At least I'm predictable.
Yeah, at least I'm somewhat following your logic, which is frightening. But
It is frightening. Let's take that for the record, Citrus County. It is frightening. All right, truck. So any motor vehicle designed, used, or maintained primarily for the transportation of property and having a gross vehicle weight of 10,000 pounds or more. Okay, so I've got Exhibit A, which is I'm reserving. I had prior reserved ruling. I'm now admitting it. It's way past the time the summons should have been here. 10,000.
I can't speak for him, but I know it was mentioned something about a lunch break too in there.
Oh, you think it was construed as a lunch break?
Yes.
I do, especially because.
And that's why a lot of people haven't come back.
because I think that the neighbor that is very upset about this and I've talked to recently was here too, and now she's not.
And
That tells me, unfortunately.
she has made it clear that she wanted to be here
Yeah, she
several
wants to
times.
speak.
Okay. Then what I'll do is let me look at this. I'll tell the county let the county know that I want to think about the issue of assessing the one-time fine. I definitely understand the logic that I believe I can find a violation even if it's brought into compliance. And under that logic, I should be able to also find a repeat violation under the same logic. But I want to look at it. I also would like to understand the county's basis and proof for the trucks satisfying the definition under the LDC at each time that the county says there was a violation. And I will call this hearing back. I mean, the problem is I was going to do lunch at 12:30. I was going to do that for half an hour. If they thought that was lunch, when do they think we're coming back? You know, 12:30 maybe? Maybe that's what they heard.
I think you also said like 5 or 10 minutes. Though.
Well, I did.
Yeah.
I'm going to stick to it. We're going to take lunch at 12:30. I'll call this back at 1 o'clock, and we'll keep going on the other. But you understand where I'm coming from and the kind of questions I'll have when we call it back. Okay? Thank you.
Can I look at the evidence while you?
Yeah, of course. Yeah. Thanks.
Are there cases we know nobody is here for?
I was going to call some that's here right now. Next case.
I actually like to call the cases where the people are here.
Yeah. Let's do next case on the agenda, Sharon Monroe and Sharon Monroe Living Trust dated April 7th, 2022. Case number 218-1099, Code Officer Brandon Norman, page 22 of your agenda. Expert on the case, Joanna Coutu.
I'm Sharon's son.
Okay, thank you.
You don't look like Sharon.
You never know these days.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Can you please state your name for the record?
Stephen Gledhill.
I'm sorry?
Stephen Gledhill, Gledhill.
Thank you.
Okay. Good morning. Brandon
Good
Norman,
morning.
Citrus County Code Compliance Officer. This is for case number 218-1099, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is for 3202 South Lee Way, Homosassa, Florida 34448. The property owner listed as Monroe Sharon and Sharon Monroe Living Trust, dated April 7th, 2022. I have good service via signed certified mail return receipt, and I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A will be photos taken during the initial inspection on February 6, 2023, a corrective action inspection on February 27, 2023, an additional corrective action inspection on May 9, 2023, and photos at my final inspection conducted yesterday, June 20, 2023. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, and the signed certified mail return receipt.
All right, sir, you've sat patiently. You actually were here on time. I'd like to ask you to look through these documents and let me know if you have any objection to them being evidence.
Actually, I kind of do.
Okay.
We had discussed this in the hallway a little bit ago. These last photos here, they're going to show a bucket inside my dog's kennel.
Okay.
And now I know that's just one thing, and I'm not going to deny anything else, but there's that, and just looks like, you know, I got a couple things. They're just stuff that goes in the yard. I mean,
Well, and so what I think that means is I want to hear what you have to say about
Right,
the photos.
right.
I don't know that that's really an objection. Like, unless you think the photos are doctored or not authentic.
Oh, okay.
You see what I'm saying?
I understand what you're saying.
So I want you to be able to comment on them, and in order to do that, they really have to be evidence.
Absolutely.
Yeah.
Okay. I thought you would give me another one of those. So there was two of those at one point.
You did, but you obeyed the first violation.
So you fixed whatever the first case was.
Yep.
Okay, so that's done. Is your mother alive?
She is, but she has cancer, and she's not.
Do you live on the property?
I live on the property, yes, ma'am.
Is there anyone from the public who wants to be heard on this case? Nope.
They're in Canada.
Who?
the
people who are-
snowbirds. Yeah, they.
Are you raising the fact that they're Canadian to
No, they're snowbirds.
point out some prejudice that you think I have against Canadians?
No.
know.
I love that movie.
I have nothing against Canadians. All right. So without objection, what's been proposed as Exhibits A and B are evidence. Please proceed.
On February 6, 2023, an initial inspection was conducted of the property for a complaint of junk and debris and was found to be in violation. It remained in violation of a corrective action inspection on February 27, 2023. Before I issued a notice of hearing, the occupants requested additional time to come to compliance, and I obliged. I conducted another corrective action inspection on May 9, 2023, and the property remained in violation. Yesterday, on June 20, 2023, after my pre-hearing inspection, I was contacted by one of the occupants who was very agitated with me once he found out the property had failed. He began to use vulgar language when I told him about the failure. I informed him that I would terminate the call if it continued. I attempted to inform him what was still in violation and how to come into compliance, but I was continually cut off. The occupant requested...
Is the occupant here?
Yes, it's
okay.
Mr. Gledhill.
That's me.
The occupant requested at the time for another extension, to which I informed him I was unable to do so. As of June 20th, 2023, the property remained in violation.
Well, so in looking through the photos...
progress has been made.
It does look like there's been progress. Let me see. Let me just look through all the photos. It's well documented, so... let's see. I mean, there's been a lot of progress.
I would agree.
Okay, all right.
And that's why initially I was willing to...
And they fixed the other case.
Yeah, they had another case.
And then you were still pissed off. So what's going on?
Well, I just feel like it's getting to a certain level of harassment at this point because I've put so much work into it and put so much. I've rented the trailer. I've hired people to come out, and I don't. I mean, maybe it's not. Maybe it's just me being paranoid. But it just at some point it feels like it because I feel like this should have been done already. I mean, I've had the county called on me before by the same people, and I rented it. I had a dumpster out there and got rid of it, did everything, and it looks no different than it does now. And they never had to do anything like this.
I mean, the issue is, the law is what the law is, and so far even today, I've seen and ruled on cases where the violations were less than what you still have on the property.
Right.
Really. And the reason is that the law has to be applied equally. Like if I set a precedent and allow what you still have on there and say that's not, junk and debris,
right,
then the line isn't held on all the other cases where technically there is a violation. And I understand where it would feel like harassment, but because it's it's y'all's property and everything.
Yeah.
But it's still there. And you have made enormous progress. You've abated one of the other cases, and they're not saying anything else.
Right.
I have asked them to always, tell me about the nature of the interactions. So and you're not denying that phone call probably was salty, for whatever reason. And it doesn't, again, this is an example for anyone who does watch on YouTube. It's like, it's not technically harassment because once the notice of violation comes out, they have to check. They have to see whether it's been fixed or not. If it has been fixed, I'm not going to, almost surely I won't find a violation.
Right.
They've never asked that of me before, except in cases where it happens over and over and over and over and over and over again.
Right.
So you're very, very close. Really, the only thing I need to know is how much time do you need to finish the job?
Man, I don't even know. I work every day. I'm missing out on money right now.
Mm-hmm.
And I just maybe 30 days, maybe more. I don't know.
Okay. I mean, what's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests the Special Master assess a fine of $150 per day along with the administrative cost to begin after the date that you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate to the severity of the violation and respondent's actions relative to this violation. We would also ask the Special Master to find that it's respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
I'm just looking to see how much still has to be done.
Maybe another trailer full.
Yeah, I agree that it would probably be more than 30 days. All right, so I adopt the county's proposed findings of fact. I will find that the property is in violation. I'll grant you 60 days from today to finish the job. But if it's not brought into compliance as ordered, it'll be $150 per day.
So call this guy when I'm
and be nice.
Done. Yes, sir. Definitely.
No, I'm not. I mean, I can't tell you how to talk. I mean,
I'll be
just you've got 60 days to finish it.
Right.
The fine will only accrue if it's not brought into compliance as ordered. He's doing his job.
I understand.
Okay.
That. I do get that.
All right, that's it.
Thank you guys. Thank you.
Next case on today's agenda, Faye V. Sullivan and Albert D. Fortenberry, case number 218-6060. Code Officer Julie Wilkinson, page 33 of your agenda.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name for the record.
Richard Nigel.
All right. Good morning.
Julie Wilkinson, Citrus County Code Compliance Officer. Case number 218-6060, unlicensed inoperable vehicles, a violation of Chapter 20, Article 4, Section 20-41.
Is this the same property that was subject at the last hearing? Okay. All right.
Of the Citrus County Code of Ordinances. The address is 7842 West Chelsea Court, Homosassa, Florida. Property owner is Sullivan V. Fay and Fortenberry Albert D. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during an initial inspection on April 3rd, 2023, corrective action inspection on May 5th, 2023, and photos of my final inspection conducted on June 20th, 2023. Exhibit B, a copy of the notice of violation, copy of the notice of hearing, a copy of the signed certified mail returns receipt.
Sir, you know the routine.
Yeah, I know the routine.
Can you let me know if you have any objection to these documents?
Both of those are titled and tagged. Those two are gone. No junkyard is gonna take that motorhome.
Okay.
Because it's fiberglass.
Okay.
The other motorhome in the back there, that belongs to Faye Sullivan.
Okay.
I've been trying to get her to get registration, file for lost title. No can do. Her husband ain't worth the powder to take to blow him up with. This truck with a white topper on it is a 92. It's got the same motor and transmission as my 95. I'm using it for parts and I'm going to restore it if and when I can start making money again to do such. But seeing as how my neighbor wants to keep harassing me, I can't do much. And now that I've re-herniated disc in my back and my neck and broke my sternum, there ain't much I can do now.
When did that happen?
Doing this cleanup y'all want me to do.
Okay.
I've got 2 titanium plates in my lower back with 9 screws. I've told y'all this before. I can only do so much by myself. And I told y'all last time I was here that it was going to take me time to get this done.
Correct. I remember that.
And now that I'm injured again, and I've got a doctor's appointment Monday morning for a specialist for my back. I've got to have stents put in my arteries for my hardening of my arteries. So I don't know how I'm going to get this done.
Do you have any objection to these documents as
No.
exhibits? Okay, then let's get these admitted first, because I need to understand.
Those 2 on the top page are tagged and titled, and they're legal.
Is there anyone from the public who wants to be heard on this case? No response. Well, we'll talk about it.
You didn't take pictures yesterday when you came by? I didn't see them.
Let's get it all on the record.
Because the Mustang...
When you're on the microphone, Ms. Wilkinson, I would respond. I'd wait till you get to the microphone. All right, so without objection, what's been proposed as Exhibits A and B are evidence. All right, now, let me just hear what the county has to say. So what's the county's case here?
On April 3rd, 2023, I conducted an initial inspection and observed the property to be in violation. On April 4th, 2023, a notice of violation was issued for unlicensed and/or inserviceable vehicles, which is a violation of the ordinance listed above. On May 5th, 2023, I conducted a corrective action inspection and observed the property remained in violation. I have had contact with the property owner. As of my final inspection on June 20th, 2023, the property remains in violation.
What are the vehicles that are violating?
Can you say that again?
Well, so this is Code Section 20-41. It's a violation to dump, store, place, or deposit abandoned, unlicensed, inoperable junked vehicles. What are those vehicles? There's a bunch of them in these photos. Are they all, according to you?
Some for being unlicensed and some for being inoperable.
Let's go through each one. So on page 1, let's see. What are these? Which applies on these first two on page
So-
1 of Exhibit A?
On the first page, the truck is not part of the case, but the red car, he indicated to me that it was not running at the
Okay.
time. So that's why I included that in.
Inoperable.
Yes.
Okay. So, as to the best of your knowledge, and I'll hear from him,
Mhm.
but to the best of your knowledge, that vehicle is still inoperable.
Yeah, because I haven't been told otherwise.
Okay. On page 2, there is a white kind of van bus, kind of minibus. What motorhome? It's a motorhome?
Yeah.
That's the fiberglass one that he.
That's the okay. And really, that's a motorhome?
Yes, that's
Is that
an 88.
how does that violate the code?
It's untagged.
It's untagged. Okay. So I just want to keep track. All right, and then on page 3, we have it looks like an old Ford truck or Mercury of some kind. I don't know. What are they?
So there's two vehicles in that
Yeah.
photo. They're inoperable. And presumptively, I don't know if they're tagged or not
Okay.
because I can't see that.
Your case is that they're inoperable.
Yes.
They're gone.
Okay, so let's look at page 4. There is what on page 4? It looks like there's another truck.
Yes, that's
With a
another.
white stopper on it?
Yeah.
Yeah, that's my old work truck.
Is that inoperable or unlicensed?
Inoperable.
Okay.
Because I don't know if it's licensed or not.
Okay, inoperable.
No, I had to take tag off of it, but on the one I'm driving now.
So it's unlicensed,
Right.
is what you're saying. Okay,
But it's titled in my name.
gotcha. All right, and then page 5, is that another fiberglass?
No, that's the motor home that Faye Sullivan owns.
It's a motorhome?
Yeah.
I gotcha.
And it's untagged.
Okay, so page 5, motorhome, untagged. If this was Orange County, Florida, they already would have just said there was a violation without looking through the evidence. Message to Orange County, Florida. Anyways,
This is Citrus County.
yeah, we actually look at the evidence in Citrus County. So let's look at page 6. That's another view
Of the same motor
of,
home.
yep, all right. And I think all the others are just, are there any other vehicles subject to this case?
No.
Okay. So you said 2 of them are gone?
The Mustang and the 89 Dodge are gone.
Okay. And those would be the ones on page 3, correct? Okay. I mean, when did they leave the property?
About 2 weeks ago.
Okay. Do you have any information otherwise?
No, they were gone when I was there
Okay,
yesterday.
so they're not a part of this case?
No, they're not. They're gone.
Okay. That leaves the red inoperable Chevy, Monte Carlo. And then page 2, the white minibus. I'm sorry. Motorhome. Page 4, the inoperable unlicensed, and then page 5. So it's 1, 2, 3, 4. Are there any? I mean, I
Monte
think
Carlo, I can drive it. I just got to put transmission fluid in it. The front seal's leaking.
I'm just thinking to myself
And
that
I do drive it every now and then.
yeah. Let's see.
I just can't afford cotton picking transmission fluid.
Well, look, I mean, that's basically testifying that it's inoperable.
I'm driving it at times.
Without
I
transmission?
switch. No, it's drivable, but I got to put transmission fluid
I
in.
understand, but that's the same as saying that. Oh, wait, you are driving it without the fluid?
I put fluid in it to drive it.
He puts fluid in it when he's going to drive it.
I see. Okay. Okay. All right. I actually will find that that's a valid thing, because it'd be the same as saying that I put gas in the car to drive it. It doesn't mean that it's necessarily inoperable. So the only reason that that car wouldn't be operable is because you just need to put a fluid in it.
Right.
Okay. Do you have any reason to believe otherwise? No. All right, I'm going to remove that from the case. That leaves the white motorhome. It's untagged. So.
Motor's locked up in it. There ain't no reason to tag it.
Well, it's got it. You do have a reason. The reason is that it currently violates the Citrus County Code.
I was using that for a storage shed.
Right.
And the old man that turned me into the county has been harassing me ever since I got out of prison. Because he and I had a run-in when he let people come in there and steal stuff out of my property. Off of her property. It's not my property, but I live there until I decide to move, according to her written statement. He's done nothing but harass me.
I understand. But it's still a violation of the code.
Well, tell me where I can get rid of it and I'll get rid of it.
Well, maybe you can tag it.
With a locked up motor.
I don't know. I mean, but that's what you got to do. It's either got to be tagged or removed.
Well, like I said, tell me where I can take it and I'll get rid of it.
How much time?
Every junkyard I've called will not take that because it's fiberglass.
Okay. How much time do you need?
Well, I can't pull it out with my truck because I almost got stuck trying to pull it out in my own yard. And like I said, no junkyard wants it because it's fiberglass. They've got to strip it down and then take the fiberglass to the landfill, and they're not going to do that. They've already told me that.
Why won't they take it because it's fiberglass? I mean, I just don't know anything about that.
You can't get rid of fiberglass except at the landfill.
Is it dangerous? I mean, is it?
I don't know. Ask them.
Okay. So the other thing is page 4, the inoperable unlicensed vehicle. Page 5, StarCraft. They've all got to either be tagged or become operable. How much time do you need to fix that?
The one around back, the big motorhome runs. I'm just waiting on her to file for a lost title, which I've been trying to get forever.
How much time?
I don't know.
Okay.
It's up to her to get me the title so I can get it tagged.
Well, it's up to me at this point to figure out the time. And
no, the 92, I'm using parts off of it to keep my truck running now.
Mm-hmm.
Because the transmission went out in it. But the topper on it, I've got all kind of tools and parts in that topper because it's a work topper.
All right.
And I might have to pull the motor out of it to put in this one because I burned it up.
Well, sir, I get it. I mean, I'm not. I understand the situation, but I have to. My job is to find a violation or not. Well, there's 3 violations on pages 2, 4, 5 of Exhibit A. So I'm going to provide an amount of time that's a reasonable amount of time to get it fixed. In Orange County, it would have been 5 days. In Citrus County, it's going to give you an actual chance to get it done.
Well, now that I can't work on my riders that I pick up to sell, I've got no extra income.
All right, so I'll come up with a time. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the Special Master assess a fine of $50 per day per violation, along with administrative costs, begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. We would also ask the Special Master additionally to find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
All right, I am going to find that the property is in violation. I'll grant you 90 days from today to abate these violations. Specifically, it's on pages 2, 4, and 5 of Exhibit A. The white motorhome, the inoperable and unlicensed truck on page 4, and the StarCraft on page 5. If the property is not brought into compliance as ordered within the 90 days, it'll be a $50 per day fine. That's it.
All right, thank you.
Thank you.
Did you want to
Is everyone here?
Yes. Yes, sir.
Is the county prepared to address my questions? Okay, then let's do it. No? Well, if they're here, I want to call it. I mean, yeah, I'm not going to keep them waiting. And the person from the public is here? Okay, well, let's call it.
Next case on the agenda, Josephine, Richard, Diana, Chris, and Edward Selman, case number 218-5478, Code Officer Julie Wilkinson, page 31 of your agenda. Expert on the case, Joanna Coutu.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Can you please state your names for the record?
Christopher Selman.
Diana Selman.
Thank you.
So what we're doing is the time is 12:01 and we're bringing this case back. I did call it back up because it was the next case. I've admitted the exhibits. I want you to take a look at the exhibits. Have you been provided a copy? All right. So I think I probably, okay. What I want to do is ask you to look through these documents and let me know if you do have any issues. Frankly, I've already admitted them into evidence, but I do want to know if you have any comments about them. And I want to hear your defense. I have asked the county to look into whether or not these qualify as trucks under the Land Development Code. And they have told me that the property is in compliance today and that as it stands, there is no violation. But the testimony has also been that there have been violations and then it's fixed and then it's brought back into compliance, or then it goes out of compliance and then it's fixed, and this has gone on and off. There's also been testimony that you don't believe that the property is subject to the code or that you intend on continuing to violate it with the trucks. So I'd like to hear from you. What's your side of the story?
Well, I negate the last part of that. That was never stated.
I just want to know. What's your perspective?
Well, that's just my opinion. We've never stated that. We don't believe it's not the code.
Okay.
The question that we have, because I had a long conversation with JD and the city commissioner, Steve Howard, and the issue that we have is, we need to be 5 acres. So we've got varying issues with the 5 acres to get the variance. We've got the city, we've got 2 plot, and we also have, how do you want to put it? There's a discrepancy in the math from the city. So we've got 2 different square footages of the property.
It's the county.
The county and it's both. Because
You're in a city?
No, it's county.
Okay.
So it's county, but what's the other one? Where did you get the records from?
This is from Citrus County residential data.
Okay.
And what it says here is that our property is 331 feet by 626 feet.
What is it? 331
by 626.
626.
So if you take that,
I'm running the numbers.
Okay, could I approach you with this?
Just give me 1 second, and then if I divide.
So if you calculate it.
43,560.
Yeah, I did. It's 4.711.
Yeah. So that's 2,207.
Square footage.
Yeah, the square footage is what I went by. So they're telling us we have 206,558.
Yeah, I think that's right.
It's 207.
Okay.
206. So
Okay.
what's happening is we're running up against, we're trying to get a variance. We have 5 acres. You had to have 5 acres to actually build on property at the beginning. Okay. It was Rovin Farm. That was the speculation.
It was what?
Rovin Farms.
Oh, I see. Okay.
Okay, so you had to have 5 acres to build a house. So with the 5 acres, we could get a variance. We own the road. It's a private road. We own the road. He comes and he does deliveries. He leaves. comes back, maybe does another delivery, leaves, comes back. So it's maybe 12 times out of the year. So we're trying for a variance. We've talked to people to come survey. Everybody is backed up since this COVID, and plus all the new people moving into the area. So we spoke with JC many times. We spoke with Lori many times. We're trying to do whatever is necessary to stop this or alleviate this issue.
Well, what you're trying to do is to alleviate the issue by getting permission to keep doing the deliveries and keeping the truck there.
Well, we don't keep the truck there. That's the whole thing. We're there during the day. That was one of the agreements that I made with Steve and JC.
I'm sorry.
Go ahead.
Okay. I made
No,
agreement.
I'm not ready yet. I understand. I want you to remember, and I want to hear from the county, but I still am trying to hear your side of things.
This is a conversation I had with them.
It's irrelevant to
and
me.
he hasn't given me a definition on the word delivery yet.
Well, no, but what I'm curious about is how long is the truck?
From sun up to sundown one day, and then at sun up to sundown another day. I'm parking on a private road, which I believe, if I can ask the deputy, is okay for a
No, I don't want to hear although I believe the deputy may have valuable information to offer. I'm the one in charge of the hearing, just so you know. So, sun up to sundown. When you say sun up to sundown, is the truck getting there at sun up?
No, like 10, 11, 9.
Okay.
Yeah.
And then it stays, for example, till when?
Till 4 or 5 o'clock.
Okay.
And at that point, with the heat of Florida, it's going to be running for a little bit.
Okay.
And if I do idle the truck, it's going to be idling for any amount of time, just to charge batteries, keep my food, my stuff, my personal belongings.
Where do you keep the truck otherwise?
Where I live.
Where's that?
I live in Montana.
Downtown?
Montana.
Oh, Montana.
Montana.
Okay.
Okay. One of the other issues we're running up against is my quick deed. Okay, our original quick deed, the last sentence of the description says accepting. So to me that means accept, right?
Mm-hmm.
It says accepting the east 31.5 feet as a road right of way. So it's saying it's a right of way. So we own that right of way. So we own part of the road. We allow our neighbors to go down the road. Okay.
Two things. You had another document that I thought you wanted to.
Go ahead.
So what I'd ask is that you provide it to the county so that they can look at it first. Yeah, and then let's see if they have any objections to it. It might be evidence. Is this your only copy?
Oh, it doesn't matter.
Okay.
I have it in my phone. This was taken off the website, and this is just my calculation.
I just want to know if the county has any objection, then I'll have that be evidence.
We also have a bill of lading in that also for the delivery.
Okay.
Yeah.
Property appraiser's website says 4.75 acres. But that's not the page that's here.
Okay.
So on the property appraisers, the footage is actually calculated incorrectly.
Can't say.
Let me I just want to know if this document is it different than any document I currently have?
And it's a copy of part of the property appraiser's records, that's all.
Actually, did I lose the exhibit again?
I think it's still over there.
Oh, okay.
We still have it.
Oh, okay. Did you have any objection to those documents?
Well, that was part of the delivery we did during the daytime, yes.
Gotcha. So that's commentary. I'll want to know.
Yeah, I'm not gonna.
I'll ask you questions about it. Thank you.
Yeah, go ahead.
So this other. All right, I'll let the county attorneys look at this. And once they get through that, I want to go through I guess a quit claim deed. I'm not sure. You called it a quit deed. I don't know what it is.
Yeah. Well, yeah.
Okay. And I'll ask you to also provide that to the county. They'll let me know if they have any objections.
I'm gonna object to the bill of lading.
Okay.
It doesn't have any information regarding date or who's shipping what to who.
The name is in the shipping, but.
Is that the only portion that you're
She's
objecting to?
identified those as her handwritten notes.
Is that the only thing you're objecting to in
Yes.
that document? All right. Oh, the whole thing's oh, I see. All right. Okay. All right. So let me ask you some questions about this. It's 3 pages. The first page is a bill of lading. The second page appears to be a screenshot of, I think that's from the property appraiser. Is that right?
Yeah.
Okay. And then page 3 are your handwritten notes, correct? Okay. So what I'll do is I will. Can you represent to me what the first page is? I mean, it's titled a bill of lading, but tell me what it is. Tell me what it does. What it means.
Bill of lading is basically something that is a document for providing shipping.
Correct.
And 99% of the bill of ladings I've get for the last 11 years of driving a truck. And before that, if I want to state for record, it was 9 years as a reserve deputy for the sheriff's department for Montana. It is more than frequent that no dates are put on it because they don't do that for many reasons. Most of them is a legal terminology because of paperwork that's designed for, how do you want to put it? There's contracts that are drawn out for shippers and the receivers. And so dates are incohesive because they're normally either stamped or signed. When a person signs it, they have the ability to put a date on it. It's not necessary by law. And it will only come into play as if it was a late delivery or something to that effect that would break the contract.
I have had situations where bills of lading don't have dates on them. I've also had bills of lading that do have dates on them. But there are reasons why you may not put a date on it that are customary. So I agree with that. What I'm really asking is, what is the meaning of this bill of lading? What are you trying to tell me?
It was a delivery for something that my mother wanted.
Is this evidence of why the truck was on the property at some point?
100%.
Okay, so where was the delivery to?
The house.
Okay, for the property that's in question.
Right.
Okay, when was this document generated?
That's a copy of the photostat, so it would have been back in March.
Okay, I'm going to admit the exhibit subject to the following conditions. This will be Exhibit C. The bill of lading is admitted solely for the proposition that you're making deliveries, okay, or that you have made a delivery. I think it's undisputed. I don't think anyone is objecting to page 2. Page 3 is admitted not as evidence per se, not as evidence, but as your memorialization of the math involved. Okay. And so I want to understand it. Are you saying that you have 5 acres?
Yes.
From what we can tell, yes. But we're waiting on the actual survey.
Again, you had to have 5 acres at the time to actually build a house. And we're the only area with a private road. Everybody else in that area does not own their road.
Okay. I'm now looking at the quitclaim deed.
So the next.
Actually, just give me 1 second. Some people are able to listen and read at the same time. I'm not one of those people. So on the quitclaim deed, what it says is it gives a legal description, and it says tract 28N of Rovan Farms, an unrecorded subdivision described as follows: the north half of the southwest quarter of the northwest quarter of the northwest quarter of section 35, township 19 south, range 18 east, Citrus County, accepting the east 31.5 feet thereof for road right of way. That means that the east 31.5 feet is not owned.
Okay, so the newer, up-to-date deed says accept.
It's the same thing.
Same here.
Yeah, what it
So-
means is that this east 31.5 feet that's used for a road right-of-way is not included in the ownership under this deed. And also it sounds like if there's a more recent deed. I mean, is there a more recent deed? Okay, well, either way, the legal description accepts the east 31.5 feet, meaning it's not conveyed.
Okay, so we're trying to go through, get that changed.
Well, I'll admit this quitclaim deed as Exhibit D, but what's the relevance
Because you
for
have
this
to
case?
have 5 acres for the
Oh, okay.
code.
So if you have the east 31.5 feet, you think that you'll get the 5 acres.
Correct.
But you don't.
Originally, you needed 5 acres to build a house.
Okay.
The house was built in 1984. Okay, so back then, 5 acres was 5 acres.
Well, actually, under this deed,
changed.
it's from Josephine Selman to Josephine Selman and Andrew Fitzgerald.
That was not the first deed that they got.
No, my point is that the grantor, Josephine, hasn't conveyed, it may still have that 31.5 feet. I don't know. That's not even.
And we don't either. That's
Yeah,
what we're
okay.
trying to find out.
All right, so let's get back to the.
I've been to records.
Yeah.
I looked through microfiche for hours. I've been to every department trying to get the answer on how to go about this, so we can actually.
I hear you. And so the thing is, under this code section, even if you have 5 acres, it's not necessarily allowed, though I think that you have to get it approved as a conditional use.
Right.
I think the county, if you satisfy all the conditions, is required to allow you to have it if you satisfy all the conditions. But that's not, I think that would be relevant only if I find a violation and I give you a certain amount of time to comply, because then it would be up to you to go see if you could get a variance or some kind. I don't know if you can, but that's where that becomes relevant. What I need to know first from the county is, what is the evidence that this is a truck?
So I did a quick Google research, and for the most common type of semi-truck is a Freightliner, because it's too far for me to tell what kind it was. But I do know.
Sir, let me ask you this: what kind of truck is this?
My truck?
Yeah.
Is a Freightliner.
It's a Freightliner. How much does it weigh?
Empty, 17,000 pounds.
Okay, satisfies the definition of
Yes.
truck under the code. So you're saying this on page 1, this blue, it's 17,000
Yeah, it's
pounds?
fairly light for this size.
Wow. Okay.
25,000 is broke, but then you got to remember we're allowed to hold 80,000 pounds. So when you look
I know,
at
but
registration, it says
I just
up to
can't
80.
believe, like, what on earth? Okay.
Yeah, I can only buy.
Well, you got to have evidence, and last time you didn't, but here you do. So you've proved that it's a truck under the code. And do you have? Does it violate the code for the truck to be parked there for a temporary amount of time, or for the time that they've testified that it's there?
Yes. The one loading type, if you get a delivery and you're doing it at that time, sure. And just a reminder, I know you probably remember, there's somebody in the public that wants to testify.
I do.
too.
I definitely remember. Okay. It's just before I even get to that point, I need to see if the county has enough to sustain a violation. And trucks as defined by this LDC shall be allowed as a conditional use. Shall be allowed. It's not even a parking restriction. It's just allowed.
Christian.
Yeah.
what is the legal definition of the word delivery? There isn't one that I can find in our books.
Well, in that kind of a situation, we use the common sense. We look at a dictionary. I'd have to look it up.
Right. Well, I'm gonna throw this in, and just as again being a trucking term, I've been at many shippers, and I've stayed 11, 12, 13, sometimes 34 hours at a receiver to wait to get offloaded. Even more so with Corona hitting. So what is quote unquote the legal definition? I mean, I know common sense comes into this, but now let's compound that. Like say I'm there for say 10 hours and I'm out of hours and I can't legally move the truck because I'm out of hours.
So I think you're inartfully raising the issue, and I don't mean that as a criticism. I'm a lawyer, right? So I don't get out much. What I am going to say is I think the bigger point you're making is that if you're not, how could it be that you can have CL, RUR, MDR, PSO, NEC? Are we saying that trucks are not allowed to make deliveries to these properties?
Of course not,
Okay.
but that would be an act of delivery. That wouldn't be, the 10 to 4. He's talking about delivering to, areas that take the truck deliveries. No one's going to say you can't have a moving van that day. This has gone far
When
beyond
it's
that.
empty, that's clearly not a delivery.
Correct.
Okay.
That's a true assumption too. Plus the loading and unloading, frankly, is in the A section, but understood. If you have a delivery, you're delivering a fridge or something, you have to take
I'll tell
unload.
you, the code requires that I defer to you
Mhm.
if it's ambiguous. This word shall be allowed, I mean, if you take it at face value, it could include deliveries.
It could, and we would not bring a case to you if that was a one-time delivery thing. This seems to be a repeated pattern.
What's the difference between a one-time and a repeating habit? Are you saying that Walmart doesn't
Well,
receive?
if you guys, you have to direct your
Okay,
comments
I'm
to
sorry.
me.
I apologize for that.
And I do have some things to think about here. In the meantime, I would like to hear from the public. Ma'am, you've been waiting patiently.
That's okay. Good afternoon, I think it is. Oh, I'm sorry. Sally McDavid.
Do you swear to tell the truth, the whole truth, and nothing but the truth? So
I
help you
do.
God? Thank you.
Thank you. I can answer some questions that have already been raised, but the first thing I'd like to say is I'm the one that brought the complaint a year and a half ago. And since then, as they explained, we've been playing this game of whack-a-mole. And the unfortunate thing is we really shouldn't have had to be here because on 2 occasions, my husband spoke with Josie, the mother, and asked her to have him pull the truck up to Shady Oak and turn it off. I was over at our barn, I think it was in mid-November, it could have been October, I can't remember, I'll have to look back, and it's all in the information I've got here for you. I walked out of the house about 2:30 in the morning because I wanted to go check on my horse. As soon as I walked outside door to the garage, all I smell is wafting diesel fumes, and of course could hear it. And so I walked on over to the barn, and we've been discussing this for some time. We've lived there since 1986, and I can assure you that in Rovin Farms on Shady Oak, Hills Point, and Rovin Point, which is where we live, all of those tracts are 4.75 acres, period. I have a copy of the deed from Rovin Farms to the Taylors, from whom Josie brought the property from, and it plainly shows it's 4.75 acres. They're generally like 3, and it does say except 31.
So everyone uses that right of way.
Yes, it's not a private road. They think it is.
Well, no, it may be a private road. I don't know.
It belongs to Rovin
but you're
Farms.
allowed, but you're allowed to share a private road pursuant to
They
easements.
don't own the property. That's the point I'm trying to make. Rovin Farms, unless something has happened since the deed was originally given, it's owned by Rovin Farms. I know we bought in '86. Our contract was contingent upon the owners of, we bought 2 tracts, of those 2 tracts signing the agreement to have the road paved through special assessment with the county.
That is something
And that all
we
went
do.
through
Yeah.
our deeds. The 4.75 acres we bought that's to the north of us, that was a third property we purchased a few years back. It also says 4.75 acres. Some of them may be off a little bit, but not much. And we put a mobile home on one of our tracts in 1986. There was no requirement for 5 acres. I can't speak for 1984, but somehow I don't think that's part of it. And and I'll be happy to give you.
Well, I don't know when this code, I don't know when it was implemented, but.
Well, in 1986, we had 4.75 acres that we put the mobile home on. Okay. We left the other 4.75 acres.
It's not actually relevant.
Okay, well,
whether it's 5 acres or not.
And the land development code says over greater than 5 acres. So even if they had 5 acres, there's a question there. But I have a disk drive or flash drive for you. And where I started, I'm sorry, we shouldn't have to be here, because after that night, I sat there and I thought about it. I said, this is going to go on forever. And we're going to listen to this diesel churn 24/7, because that's basically what he's done. And we believe he has lived in it up until probably the last 2 trips in March and May. And I have gone to the barn, to the house. I have consistently, whenever he's been there, taken videos, not so much for the visual, but for the audio, to prove that not only is he there for days on end, he's also running it. Now, since March, and whenever the initial little last hearing was, I will say he's parked the trailer 45, 50 feet, something like that.
Wait, last hearing?
Pardon? I thought there was some discussion. Was it a hearing?
Okay.
Okay, I'm sorry, my mistake. But he has parked that out on Shady Oak, on the easement of Shady Oak up by Noble. But then I sent Josie a text with the video thinking, if she hears, my barn is like 500 feet from where he was parking the trailer or more. And if I can sit in the aisle of my barn and record the sound that truck is making at 2 o'clock in the morning, 7 o'clock in the morning, 5 o'clock when we're sitting on the pool deck, in your own mind, and you can hear it on this, and I've got all the video and audio for you, that if you're in person, it really does sound even louder. So I sent the text thinking maybe if she heard that she might say, okay, let's move it up to Shady Oak and turn it off. They didn't. So I wrote a letter, and I quoted and I have a copy of that for you here also. I have a copy of the LDC. I highlighted it for. I had a screen print off the property appraiser's office and told her that they can't get the conditional use based on the ownership of the property. And of course, I had no idea they were going to try to say that over the course of the last year and a half, he's making deliveries to his mom. But that's a whole other story. But I can even prove, or I can't say I can prove because I don't get up during all hours of the night to take pictures of the truck in the pitch black dark. But I do have pictures, matter of fact, that the one that I find particularly interesting is from April of last year that shows the truck parked. And I looked at it, I thought, well, what in the world? There's a piece of plywood in the passenger side window of the truck and the trailer, because he's only just started disconnecting the trailer, with an extension cord run to where Mom's RV sits. So why would he need that if he wasn't living in the thing? It's not going to run his refrigerator. It's not going to charge his batteries. So there's no other reason for him to run that thing 24/7 if he's not living in it. So I have a set of still shots here for you. And the first one, I did a plat map for you where I can show you the location.
Just one moment. I will give you a chance to respond, just so you know. That's called fair game and a hearing.
Oh, absolutely. Absolutely.
But I do want to hear everything you have to say.
Okay.
And you have that right.
Okay, bring it up.
So you have evidence. Tell me what evidence you have exactly.
Okay, I have the letter that I sent to Josie, in case you were interested in that. I have a screen print from where I sent the text. I have a copy of the property appraisers where it shows 4.75 acres. I also have where she's written deeds in the family, and then the very first deed that went from,
This is the title record. We'll just call it the record of title from your perspective.
It's a warranty deed.
Okay, we'll call it the record of title from your perspective.
And this was from March of '82 from Rovin Farms to the Turners.
Okay.
Less 31 and a half feet on the east
I understand.
side.
What's the next document?
Okay, those three, that one. I have a list of the dates that he was here.
So it's a memorialization of your observations of his presence
Substantiated
with the truck.
Substantiated with photos.
Is that a yes to my question?
Yes, it is.
And then with the, it's a USB?
I'm sorry?
Is that in the envelope? It's a USB, a thumb drive?
Yes, it's
okay.
a flash drive,
What's on the thumb drive?
Pictures, videos, listening to the truck run at all hours of the day and night. And I have this document, which has a
Do we have a
variety.
way of playing what's...
I was gonna.
I can.
I don't think so yet. We're almost at lunchtime.
Oh,
I'm sorry
that.
to say.
Well, I'll be happy to try to play one. Just let you listen to it from my phone.
No, I have to have it on the thumb drive because that's what the evidence is. But we also need to give them an opportunity to review these documents. I need to know what objections they have as well.
Okay. Do you want to look at these?
It's 12:30, so what I want to do, I just don't know how long we're going to be here, and I've made the mistake of driving everybody till 2 and 3 p.m. before. I don't want to do that anymore. So what I'd like to do is arrange for them to be able to review what you want to submit, and then I'll hear their objections when we get back.
Okay.
Okay? And then I'll make a decision on admitting it as evidence or not. Is that okay? Can the
That's
county
fine with
help
me.
do that, make sure the evidence doesn't go.
Now, are they going to take this with them, or are they going to
No,
review
I
it here?
want it to be done here.
Okay.
I don't think that we need to be in the hearing for them to review the documents, but someone needs to have custody of the documents from the county. So
Okay.
That's all I'll say. So the time is 12:32, and I think what we'll do is we'll be back.
I almost brought my laptop, but that may not have been acceptable either.
No, you would have to turn it in. You don't want to do that.
Darn it.
If you have to drive somewhere, I'd say 45 minutes.
Yeah, I was gonna say I've pulled it off in half an hour before, but it wasn't pretty. And as we all know, at the last hearing, I picked up a speeding ticket. So
Didn't you?
I was late. I was like 30 minutes late. Yeah, I put it on the record. And you know what? I didn't contest it. I was guilty. and everyone, should follow the law. So let's come back at 1:15.
1:15.
Well, that's when we'll bring the hearing back to order. All right, thank you. Is the county ready to proceed? Yes. But what I want to know is, actually, have you guys had a chance to review the proposed exhibits?
No, we did not.
No.
Okay.
We're trying to make sure they were.
Well, then let's do it now. That's fine. I mean, it's okay.
And we are able to play them through the.
Fantastic. Awesome.
You just let me know when you're ready.
I just wanted to give them an opportunity to review the documents and let me know if they have any objection to them being evidence in this hearing. And ma'am, could you come back up to the microphone? Yeah. You might have to explain some of this.
When you click on a file, the file name, it should have been like number 703 or whatever, it has a date and time,
I
like
see.
AM and PM. So that'll give you a clue as to, and but I think and you'll need to turn the volume up, because again, I was using my iPhone to record it from 600 plus feet away.
Okay.
I don't know that all speakers record things.
The location's respected.
You made it back okay?
Tickets?
He's laughing. He's smiling.
They got me again.
Were you in that red
No.
car? Wait a minute.
No.
Were you in the red car?
Where
Were you? It was right in front of Dunkin' Donuts.
I am not. I didn't even say anything. I just took, it's. Yes, Citrus County is out in force right now.
Yes, they are.
And
It is a 45-mile-an-hour zone.
It was a 45-mile-an-hour zone, and you know,
They're serious.
it's never happened to me before.
That's
You know,
two?
Now you're gonna have to do the school.
2 in
or
a month.
something.
Yeah, so this is a new experience. Thank you for asking. That's what I would have predicted before lunch.
So what's funny, I actually pulled out of the Dunkin' and I saw a red car pulled over and I'm like,
Yeah.
huh, we were just talking about that. Then I pulled the U-turn at the light to come back and I'm like,
Was it worth
It's
your
a red.
lunch?
No, I was coming back from the Wawa, and
Now your children are not gonna be able to go to college.
well, let's just say I see both sides of code compliance, you know. And so, anyways, do you guys have any objection to the?
You know, this is pertaining to this case, so I don't have a problem with it.
Okay.
This is on the delivery side of it. The 414 with the on the 22nd.
Well, whatever documents there are, you'll be able to comment on. I mean, if you have.
I see one. Now, understand, this is going back like last year.
So it really doesn't pertain to today's case?
It's not about today's
It
case.
might. So what I mean, you know, the county.
And the statement that was given was that I was living in a truck.
No, I want to give you that chance
Yeah.
later.
Okay.
What I need to know is if you have objections to these documents.
I
object.
Okay, so you can object. I will give you the opportunity to speak about them. I don't know whether I'm admitting them or not until I look at them. So there are objections, and I'll go ahead and look and see if I'm going to admit them or not.
Mm-hmm. No, Barbados.
Okay, so I'm going to have this be a composite exhibit. Let me just take a look at it.
If I might, the second page of that package should hopefully give you some perspective as to where our house in Full Deck is, where the truck was parked, where the truck is now is the Green Star.
Okay, just give me one moment if you don't mind. When were all these photos taken? Were they all in 2022?
There should be dated, they're all of a variety.
Yeah, all the ones
Some were
with.
2022, I have more that I just brought from 2023, there's videos from 2023.
I'm just asking about these. So what I want to know is, are these photos, so I see one from January 5th, 2022, 2, 3, 4, 5. They're all the ones that are, it's okay, don't worry. No, not, it's okay, thank you. They're all 2022. They all appear to be 2022. Is that in this packet?
I don't remember.
That's
I
okay.
didn't have a copy for me, but
That's
is
okay.
the trailer shown in most of them?
The trailer is in many of them.
Okay.
Or if it's not connected to the truck,
If they're connected.
it's separated.
If the trailer is connected to the truck, it's probably 2022.
Mhm.
But they just started disconnecting the trailer and parking it up on Shady Oak this year.
Okay. Right. I'm going to reserve ruling on the still shots. I do think most of them are not relevant, so I'll reserve ruling on that. I'm now looking at the November 26, 2021 letter. Let me just look at that. Okay, so let's see that. All right, so the still shots in the letter. The November 26, 2021 letter, I will admit as Exhibit D, a composite exhibit that includes the mailing information. But I mean, it's really just used to show that you sent a letter that you were concerned about the property, and
All we've ever asked it to be
Yeah.
parked on Shady Oak and turned off.
right.
And the pictures that I gave you there, my point in those is I'm concerned they're trying to manipulate the interpretation of the Land Development Code with regards to deliveries. This shows how often he's there, the vehicle in a different spot, the fact that he's,
Yeah, unfortunately, we're here on a limited date range,
okay. Well, I've got videos for this year.
and so I think most of what you provided in the first document is not relevant for this hearing.
Okay.
This letter, I'll admit, I think it's also of very limited relevance in that it's dated November 2021, but it is relevant for your experience, and so you're a member of the public. Give me your feedback about this problem, and so for that, I am going to admit it as Exhibit D. However, it's hearsay evidence, so I can't base a violation based on hearsay evidence. I can take it into account regarding, the public's concern and the severity and that kind of stuff. But for the existence of a violation, I'm not allowed to take it into account. Or solely, it can't be the sole piece of evidence. Now, on the text message, is this a text from your phone?
Yes.
Okay.
And you can't have it.
I can have it?
No, you can't have it.
I can't?
Not my phone.
Oh, I got you. Let's see. Okay, I'm going to have that be Exhibit D for the same limited purposes as Exhibit D. So I am interested in the deeds. So I'll take a look at these. They have recording information. They're public records. I'll admit them as Exhibit F. And let me just review very quickly. Okay. I'll also note for the record that there's red handwriting and notations on this exhibit. Are these from you?
Yes.
Okay. So that will be fine. I've reviewed deeds. I'll admit the property appraiser document. Are we on Exhibit G? Okay. That's Exhibit G. Again, there's red markings and commentary. I think that's from the witness. I'll admit Exhibit H as supporting evidence for the input from the public. It's simply a chronological record. So am I to understand that this reflects a written record of your observation of the Selman truck visits?
That is correct.
Okay.
Along with still shots and videos.
And so when it says on January 5th, 2022, here about 4:50 p.m., that means you observed it on January 5th around 4:50 p.m.
Yes.
And you noticed that it was gone on January 10th.
Yes.
And so in the intervening days, you would have still observed the truck
Yes.
there. Okay. And all right, so that makes sense. And then most recently, and more relevant, I think, for the hearing, I see May 10th, 2023, here, trailer at Noble. What does trailer at Noble mean?
Okay. In March, he started disconnecting the trailer from the truck, trying to make some sort of confirmation to what they're trying to interpret the LDC to be. So he's disconnected the trailer. It's parked on the easement of Shady Oak, just up at Noble Street, which is the main entrance into that area.
Okay.
But
All right.
then the truck
Go ahead.
comes and goes. I did see it parked up there at Shady Oak one day, or one evening, I should say. And then I think he gave up on that idea because probably 2 out of the 3 nights he was parked in the yard, or at least it appeared to be so because it was still in the yard at 6:30 and 7 in the morning.
Okay. And then on Exhibit I, which I'll admit, it appears to be a photo from April 10th, 2022. And the reason why I'm going to admit this, but probably not the other 2022 photographs, is that you're admitting this for the proposition that there's an electric cord running, and it appears that there is, I don't know, a window AC unit of some kind?
Yes, it is.
Okay.
It goes back to my suggestion that if he's not totally living in it, he's spending a great deal of time in it, running it.
Okay, I can see the relevance of that. And I believe you also have electronic evidence.
Yes.
So we'll call that Exhibit. Are we up to J? Okay. I'd like to see it, and then is there a way to go through this one by one? This is like a full trial.
The first one is labeled location perspective.
Yes.
So I'm guessing that's going to give us.
Barn.
Here?
House.
There we go.
There we go.
Okay, it jumped
This
a
is
little
a
bit.
video.
Yes, my barn was to the left, the house, and then there you could plainly see the truck.
Okay, what date was this video taken?
It should be on there, or on, there's in,
11th, 2023.
Does that sound correct to you?
sounds like it. Be-
There's a date at the bottom.
Oh, there it is, it sure is, okay.
Okay, so this would have been taken in that interval where you said that it was there from May 10th to May 15th.
Yes, that's also the trip that when I was back there trying to take videos that he climbed out of the truck and threw F-bombs at an almost 72-year-old woman, and something else that I couldn't totally understand, but certainly came across to me as a threat.
Well, sir, let me ask you about this, first of all. There's a bunch of evidence that it appears the truck isn't leaving overnight. I mean, are you disputing?
Oh, absolutely, yeah. No,
Okay.
it leaves, like I said.
Every night?
Yeah, every night.
Okay.
Yeah.
Have you ever seen the truck there at night?
She stated that already.
It's dark by the time, if he's leaving at night, I've probably got a couple in there that are from like 7:30 p.m., I think, from what I remember in that batch of videos.
Well, you testified once that you heard it.
Oh, I hear it. Yeah.
At
well,
night?
Yes.
Okay.
Oh, yeah.
Can I add something to
Just let me keep going
Okay,
through this.
good.
I'll admit this video as Exhibit J. Well, let's keep going because maybe we can admit the whole thing. as
If
a
you look at
composite.
the
Let's go.
batch from May,
Well, let's go one by one.
Well,
So
then there's another file, there's 3 more files labeled 2021, 2022, and 2023.
2023 would probably be the next one, since it's current,
whatever the next one is, let's go and take that up.
in May.
That's March and May.
Okay, so there's the trailer over on the east side of Katie.
Can you turn the volume up?
Out near Noble Street. He's behind the trees. You That may was a be able to trailer. Hear him over the crows. I'm not sure because the wind's blowing in the other direction. That one is going to be a little difficult to hear the truck.
Truck's still there, not running for a change. Assuming the trailer's still down on the road. So we hadn't left.
This one and the
8:01
last one was
p.m.
March 24.
Does that match up with your recollection that you took it
Yes.
at 8:01 p.m.?
Yes.
This is in March?
Yes.
I have more in May.
No, I just didn't know it was that late at 8 o'clock in March.
Yeah.
Okay.
Next one is labeled March 25th at 6:24.
What are we looking at?
Well, he's got it running. Don't know if he's just cooling it down for the evening or if he's sleeping. We'll find out later.
Is that a power cord running across the yard?
No, that's a hose. That's our yard. To the garden.
Okay. Okay. What's next?
Still has the sun visors in the windshield. It is, I don't know, 7:15 or so. Came out at 6:30, but it was too dark. He's obviously been parked there overnight.
What time is this?
Thankfully, he's not running it.
Labeled 7:22 a.m.
Okay.
I tried to get it earlier than that, as I said, because it was dark, but you can see the fog even.
The next day, March 26th at 7:17.
Sunday morning, about 7:15. Sunshades are still in the window. Doesn't look like it's been moved. Haven't heard it
Can you
move.
go back to the last photo or the last video?
Still has the sun visors in the windshield. It is, I don't know, 7:15 or so. Came out at 6:30, but it was too dark. He's obviously been parked there overnight. Thankfully, he's not running it.
All right. Let's keep going through these.
Well, you can't see him through here between our hedge and the trees over there. But just trying to give an example of what we listen to if we're sitting on the pool deck. And this is Sunday morning, and he's cranked it up. Don't know if he's leaving or not, because he likes to let it run for hours on end. Okay, so here we are Sunday morning. It's about 9:30. I don't know, it's been running somewhere around an hour and a half to 2 hours. Again, sunshades are still in it. To my knowledge, it hasn't moved. Don't know what he's doing. Hoods aren't up. Hadn't seen anybody out and about, but obviously he's been up this morning. Or in it. He could have slept there last night with the cooler weather. Who knows? Okay, so he's still here Monday morning, 7:15. And the truck is idling. Now, is he leaving? Trying to beat code enforcement? Or is he just going to let it out idle for hours as he usually does? You can still see the sunshades in the window. And based on the other pictures and what we've heard, he's not moved it.
That's the end of, oh no, now we have May.
Trying to see how well it picks up from here. I'm sitting underneath the roof, pool deck, and we're grilling. Of course, he took the pan in there to wash it out after you put the meat on. And we're listening to the diesel run. Okay, so here he is, he's back, and the truck is running.
I'm over by the barn. 807.
Barn. House. RV shed. And there they are. It's not running right now. I think they've gone to town. Just some perspective. Okay, so it is 1:46 and he turned the engine off, I don't know, 5, maybe 10 minutes ago. And I think the first video I took of it was around 11-ish, 11:30 this morning. Anyhow, we'll find that out. But he finally turned it off. Don't know what it has to do with the construction he's doing, but anyhow.
The noise in that one was the fans in the barn.
I had to get away from the pool heater and the pool pump and the air conditioner running.
Sure.
Hey, sweetie. So here he is in the backyard again. He just idled down. I'm not sure if he's in the cab or not. Yep, I see some movement, so he probably just idled it down. And this is what we deal with. Don't see any construction going on. And it's daylight, so I guess that's his excuse for being here. Now keep in mind, he's parked it out by the road in the afternoon, late, and then comes in the morning, whenever I guess he gets out of bed. Real vulgar language. Imagine that. Wonder what he's saying. I just waved.
That's when he threw the F-bombs at me.
Well, it appears maybe he's getting ready to go. But it's running. I think it's like 7 o'clock Monday morning. $8:35. Still running.
That's all for 2023. There are other files for 2022 or 2021. Don't know if you want to hear those as well.
Well, what would be the relevance of the 2022 and 2020 that I don't already have?
It proves to me that he's there more than just to drop off a delivery and go somewhere. And we started this whole thing in January of 2022, and it's been back and forth and back and forth and back and forth. And to me, it just simply shows a pattern. And then now, all of a sudden, since things maybe are getting a little bit more serious, he's trying to manipulate the interpretation of the code to say he's making a delivery to his mom. Well, it's obvious that truck is in and I realize that, those are my videos. There's no doubt about it. But I can also pull up my iCloud account, and they're all time and date stamped. So there's no reason for me to lie about it. It's there. And not only that, we have another neighbor on the corner who has heard it before and even told his mom that when she went down to talk to him and wanted to badmouth us.
Well, I think the photos that you've already provided demonstrate what you just talked about. So if you're saying that it's the same thing.
Yes, sir.
Okay. Then what I'll do is I will admit the photos from 2022 and 2021 as exhibit K.
Well, is J going to be?
Yeah, it's going to be a composite exhibit. I'll admit J just, for those purposes, although I want to hear if there's objections to them being admitted as evidence. Do you have objections to the videos being evidence?
Well, yeah, I'm going to object to all of it.
Okay.
Only for this sole purpose that it's not relevant to this particular case. That's the first thing. The second thing, I didn't know we had an idle law in the state of Florida.
A what?
An idle law, meaning that we can't idle our trucks. Now, I understand, you see, understanding trucking understands why we idle. We've got 4 batteries, you know, I can go into the mechanics of how it works, but it's the very reality is I just can't start up the vehicle and let it run for a couple minutes and shut it off. They're designed to be long haul. I drive 150,000 miles a year. I don't shut my truck off at truck stops. And so when I'm there, I leave it running, you know, especially if I just started it up an hour or two beforehand. It needs to complete what
Well,
it's
that's
doing.
commentary on the evidence. It's not really an objection to what the
Right.
that they're
No,
doctored or inauthentic videos.
And again, the timestamps. I mean, we go back to the whole delivery thing. What is a normal time for delivery? There's no definition. We have an idea of active delivery, but there's no definition for that either.
Well, that's, again, not really, I'll overrule the objections and admit the evidence then, because I haven't heard an objection that's a valid objection to these videos being evidence. I do think you have things to say about them, and that's something I'll take into account. Okay, so we've gone through this evidence. What other commentary would you like to provide?
Well, just the fact that we sit on our pool deck, try to grill out, try to use the pool. When he's here, it's running. And it's been better the last 2 trips because I think he's trying to do a little something. But in my mind, that truck, with rare exception, I think probably in March, maybe 2 nights he parked it out by the road. In my mind, I truly don't believe it's been moved. Now, if I thought that would have been an issue, well, I'd have set my alarm clock and I'd have gotten up and then I'd taken a couple more still shots. Or, you know, I don't have an explanation for that. But this is a rural residential area. They own less than 5 acres. They can't get a conditional use permit with that because I'm here to promise you that they don't and never have owned 5 acres. The other thing is that from a standpoint of the visual effect, as an example, on our street, 2 lots over, we now have some parents that are allowing their adult son to, from time to time, drive his truck in there. Now, he did this a number of years prior to COVID. And I haven't said anything, haven't addressed it. We needed to get through this thing first. But those trucks, I think you said something about 80,000 pounds and 17,000 for the tractor. So that's like, if my math is right, 43 tons, something like that.
No.
Did I miss something? I think there's 2,000.
80,000 pounds is maximum gross weight. That's maximum.
Guys, I don't want to, I'm not going
Okay.
to allow it
Okay.
y'all to,
You're corrupt
it's
on
okay.
your
I know what's,
My
I just
point
want to
is,
hear your testimony.
these are neighborhood roads that, and when they pull off of Noble Street onto Rovin Point, there's no way they keep all of those tires, and I know not the tractor trailer, or the truck, excuse me, on the pavement. So it's running off the pavement onto the side of the road. We know we've got a big problem in Citrus County about the condition of our roads. Noble Street's in pretty good shape now. So, and Rovin's old, but it's still doing good. But if someone, like, and I'm not sure why Bopst is back on the next street. He's not there very often. But here he is, parked the truck, whether it's in the yard or up on Shady Oak, and somebody drives by and then they see Bopst on Rovin Point, and we've got a nice neighborhood, at least on our 2 streets, and they drive by and they say, well, wow, I drive a truck. Why am I having to pay to store it or to park it on some lot to make it legal? I think I'm going to go down to my lot in Leisure Acres and park it there. And the next thing you know, we're like a Love's truck shop. And I understand I understand there's an hour issue, because that's an industry-wide problem, because these guys, they work hard, they need rest, they're required to take a certain rest, but that's also why you see them on the side of the interstate, on the exits, and parking in Love's. We used to haul back and forth to Tennessee. with a 38-foot horse trailer and our dually 1-ton truck. And we spent 4 to 6 weeks up there twice a year, spring and fall. And we frequented the truck stops on the way up and the way back. And I understand what they're going through, but I also know what the noise level is, and the more we get these guys around, they're gonna do more. This is a residence, it's not a truck stop. And that's the bottom line of it. And I strongly believe that the comment about making a delivery or doing maintenance is simply an excuse to try to circumvent what the code is meant to be for.
Okay, thank you.
Because we're in a rural residential area. We don't have deed restrictions, which we knew that when we bought it. And the LDC is our only protection, not just us, but everybody in our neighborhood.
Thank you, ma'am. Now, Mr. Charlton, I think you had wanted to be heard on something. Before I turn back to them, because I want to hear their commentary on, I allowed the public to speak for a very, very long time. But I want you to be heard as well.
We've had this case off and on for probably over a year or so. I had issued a citation, where our former code officer issued a citation, and he was no longer working with us, so I took over that case. And the violation has been explained numerous times.
When was the original notice of violation issued?
For this case?
Yeah.
Was it in May or March, maybe?
I mean, I see March of this year?
Yes, sir.
Okay. Okay, March 27. All right, please.
The date of the violation was March 27th.
Yeah.
The date it was observed.
Oh, okay, so that's not the date in the notice?
It was given until April 26th to correct it.
The notice violation was issued also on March 27th.
Same day it was observed.
Yeah.
Okay, actually, let me look at this notice of violation, because that's actually pretty important. Was witness to be in violation, land development code. The following corrective action must be taken by April 26, 2023. Remove semi-truck trailers from residents. It is the responsibility. Okay, it's relevant for the relief that you're asking for. In other words, at the beginning of the hearing, I still want to hear everything you have to say, but at the beginning of the hearing, you talked about wanting, asking for a fine, or a finding of violation and a finding of a repeat violation that I think is in the nature of, according to section 19-55, essentially irreparable or reversible in nature. It's like when you cut down a tree, you just want a finding.
Or a finding of guilt or not, that way, if it does come again, it would be a repeat.
But just to be clear, I don't know that I can make that finding if you issue a notice of violation and say, hey, you've got until April 26, 2023 to complete that. Mm-hmm. Because that's not the case you've presented. In other words, it's not an irreversible thing. I may still be able to make a finding.
If I might interrupt,
yeah.
we have determined that this is not a one-time fine case.
Okay.
Since it was corrected prior to today's
Gotcha.
hearing, although they did not correct it prior to the date they were given.
I know, I understand. All right, so that clarifies that.
True.
Please.
That's not true. We corrected it before that.
Yeah, I left on the 27th.
Okay, we'll get into that. But the main point that I take away from this discussion is we're not talking about a one-time fine case. We're talking about a continuing, if there's I'd have to give you a time to comply, basically. Okay, please proceed.
Yes, and we just had several conversations about it. We had a meeting on a conference call about it, and I think that's maybe where he was going with maybe the delivery, because I just happened to be in that meeting with the county administrator, and he wanted the whole LDC section of that section read, and I believe that's maybe where some of that stuff came from, because it does state that in there. But like I said during that meeting, the land development director was not there to interpret that section of it. So,
But so he had testified that you had an agreements, I think, and that's when I saw your reaction. So
right, and that's where that
you're
came
just
from.
saying that you never had an agreement, so to speak.
Correct.
Okay. All right. Well, thank you.
Thank you.
All right. So you heard a lot. I'd like to give you a chance to respond to what you've heard from the public and from Mr. Charlton. What would you like to tell me?
Well, So we talk about, I'm gonna go back into the delivery, okay? And then we'll talk about dates and stuff and everything else, but outside in front of your office over here, did you notice there's all those Amazon packages?
I didn't.
Okay, so when you walk in the door, there's a bunch of Amazon packages. You know how many deliveries they get in this building a day?
No.
Probably 10.
Okay.
And who knows how long they're here for, you know, because they're delivering to each building. So I think that's where my consideration is when it comes to this, is what is the legal definition for delivery, you know, when it comes to delivering. I am moving my truck out. Now, there is no legal statute that says I can't idle my truck. Okay, there's none in the state of Florida that I know of.
That you can't what your
I
truck?
own my truck.
That you can't own your.
No,
There's
I
no
can't idle. I can't
idle.
own my
Sorry.
truck.
Yeah, I don't think idling.
Now,
is,
first of all, my truck is emissions friendly. It's part of the, you know, I don't go to California, but that's my choice.
Yeah, be
Truck's
careful
choice.
about that.
I don't. That's just my opinion. And I can't only go by opinion. I could go by the law. The law states I'm allowed to go there, so if I decided to, I could. I'm just not into it. My truck also meets all decibel levels of, you know, federal emissions.
That's
federal
not an
standards.
issue. Yeah.
Right. So that's not even part of this whole
Correct.
case. That's just an opinion that came in from a neighbor. The delivery time, I am removing the truck from the property at nighttime, and I am parking it, you know, on the road. And I'm back during the day, and I do maintenance my truck a lot. You don't get 1.5 million miles out of a vehicle without maintenance in it. And I didn't bring records, but I can assure you I've got a lot of records of stuff that I've bought. And if you're looking, you can't see it from her pictures, but there's parts sitting behind the shed that need to be scrapped. Very large components. So we've been working on the truck, and I do a lot of my maintenance when I'm down here. Because I live in Montana, it's cold. Can't maintenance it. I can't go outside and work on it as much as I can here. So I'm allowed, you know, I want to keep the truck rolling. And as for the correct amount of property, we have to get that determined because there's 2 discrepancies in those. And there's discrepancies in the square footage. So we need to get it reassessed. And that's where we're at. And then hopefully we can file for the variance. So that's all I have today. You have any answers?
My mother doesn't have a cell phone.
That's another thing, yeah.
She doesn't know how to do text. She can't do text.
She's 84 years old, and at this
Yeah.
stage of the game,
She doesn't have an email address.
she's got some health issues.
Yeah. So, and yeah, I'm here for that reason.
And I come here also to make sure that she's.
Wellness checks.
So what is the county asking me to do if the property is in compliance today? And if the property was brought into compliance before, is the county still wanting me to find that there's a violation based on the truck being there before?
We're asking, excuse me, for you to find a violation because, and based on the dates of the photos, they did not abate within the time that was provided by the code officer.
Okay, so let's talk about that. I just want to understand what the case is then. So
if they did not abate then, we can still bring it to hearing if they abate prior to the hearing and request that you find the violation existed and order that they pay the administrative costs.
Okay, so that would be under Code Section 19-55H.
A.
A?
If a violation is corrected before the.
I'm sorry, A, that's what you're right. Then the violator shall pay the enforcement costs incurred by the county. Now, let's talk about the violation, because my understanding of the dates was that it was corrected in the time. In other words, if I look at the exhibit, I don't know if it's the truck visits catalog.
I think if you look at just A and B, the photographs that the county presented and the notice.
I am, but now I have all these other exhibits, and so I have a catalog of the truck visits, and what it shows is that the truck was there March 24th to March 28th. The notice will regard it a violation on March 27th, so it's undisputed that it was there March 27th. The date for compliance was April 26, 23, but what the key witness said is that it was the next time it appeared under the list was May 10th through May 15th. So it was abated under the evidence I have based on the March evidence. If all I had was the county evidence, I might agree. But I now have a lot of other evidence, and that's what it appears to show. And then the next time, so then the next violation would have been May 10th to May 15th. So if it was abated during the time of the notice of violation, and then it happened again, is that still a basis for me to find a violation?
Well, the violation was based on the observations of the code officer.
Right.
And under her observations, the truck was there the day she saw it and issued the notice of violation, and it was still there on the date or after the date that it was to be removed. So if it left, it should never have come back.
Right.
And that's why we kept it open, because the reoccurrence, it keeps coming, going back. So then if we close it one time, then we'll be right back starting all over again.
Right.
And I believe Mr. Selman's testimony at the beginning of this hearing was that the truck is only there between the hours of 10 to 4. And we have a lot of evidence that shows that that's not the case at all. I believe his testimony has been impeached.
I agree with you. Everything he said about the timing was incorrect. But I don't find that that's key at this point. I'm trying to figure out that if I accept that I agree that they're violating the code, okay? But the issue here is that it was abated and then they came back. So what I'm asking is, if it was abated in the time allotted by the notice of violation, and then the violation recurred, is that properly before me?
We never abated it. We wouldn't have issued a notice of hearing if it would have abated. So we never abated it because we knew it was going to keep coming, but it's just the times to get out there to find it. And then we knew we were going to have testimony, and evidence maybe.
Well, we had
presented.
very powerful testimony
and
today
Christian,
from a neighbor.
Under section 1953, sub B, towards the end, it says if the violation is corrected and then reoccurs,
That's what I want to
may
know.
be presented to the code enforcement compliance magistrate, even if the violation was corrected prior to the date of the hearing.
That's what I want to know. So where is that?
It-
At the end of B.
At the end of B.
Okay, let me read that. That is what I was asking about. Okay, so I see code section 19-53 subsection B, and the relevant language is, if the violation is corrected and then recurs, or if the violation is not corrected by the time specified for correction by the code compliance officer, the case may be presented to the code compliance special master even if the violation has been corrected prior to the board hearing. So here's what I'm going to find. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess enforcement costs. This amount was selected based on the actions of the property owners once they were advised of the violation.
So this is an unusual case, as everyone in this room knows. I frankly do agree with you guys that you abated the violation, but I do think that the violation has recurred. And I do think that, at least as it stands today, it seems like there isn't currently a violation, but what the code section allows is that if there was a violation, I can still make a finding that it existed. The reason why this is relevant for you is if I do find, and I'm going to find, that there was a violation in May, but only in May, if they determine that there's a recurring violation, there's going to be a daily fine for each and every day that it's back in violation. And you'll be appearing in front of me again if that happens. So I will find that the property was in violation from May 10th to May 15th, not assess an individual fine for that, but pursuant to the code, I will award enforcement costs because I'm required to do that. And that's it. Thank you.
Next case on the agenda, Veronica Dono, case number 218-5664, Code Officer Brandon Norman, page 13 of your agenda. Expert on the case, Joanna Katu. Thank you.
Thank you. Put in a good word with me with the sheriff's office. Okay, listen. They see a red truck, Anyways, are the hearings taking longer, or is it just me? Like, am I making these things go longer, or is it that more people are showing up?
There's a lot of cases on this.
Okay.
Plus, there's 30-some cases, and then everybody's had a lot to say.
It just seems like it's developed.
All my people aren't here, so we're good.
Well, it just seems like it's changed over the years. I don't remember it being like this. I don't know if I'm encouraging it or... Anyways, go ahead.
Okay, so good afternoon. Brandon Norman, Citrus County Code Compliance Officer. This is case number 218-5664, Development Applications Applicability, a violation of Chapter 4, Section 4002 ABC of the Citrus County Land Development Code. This is for address 4525 East Rejoice Street, Inverness, Florida. Property owner listed as Dono Veronica. I have good service via certified mail return receipt, and I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A will be photos taken during initial inspection on March 23rd, 2023. A corrective action inspection photos from May 12th, 2023, and photos from my final inspection on June 19th, 2023, as well as aerial images from the Citrus County Property Appraiser website for the year 2021 and 2022. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, and a copy of the signed certified mail return receipt.
Is there anyone from the public who wants to be heard on this case? Nope. All right, thank you. Without objection, what's been proposed as exhibits A and B are evidence.
On March 23rd, 2023, an initial inspection was conducted of the property for site modification without permits. This property was included in a larger investigation of the Inverness Villages 4 development for a complaint of site modifications and junk and debris. The property was found to be in violation of the above ordinances due to not having permits issued before the removal of trees from the lot. The aerial photos show the trees were removed in between December 2021 and October 2022. A permit was issued for the property on April 11th, 2023, but the aerial photos show that the property was in violation since at least October 8th, 2022. The removal of these trees has played a factor in the severe stormwater retention and ecological issues affecting the residents for this development.
How do you know that?
We have an expert who can test.
Okay, yeah, that's I'd love to hear.
Experts. You got us both today. All right, this is a medium density residential site. A building permit was issued on April 11th, and trees are completely removed, so they should not be until April 11th. Would have given them permission.
Got it.
Other expert?
And the other expert. Among my other qualifications, I'm a licensed state of Florida stormwater inspector.
Wow.
Anytime that you denude a site and don't have any type of stabilization or best management practices, you run the risk of windborne debris in the dry season, dust. You run the risk of uncontrollable runoff, in this case, into the right-of-way and into adjacent properties, as there were no management practices present at all.
The risk, but was that present here?
There's nothing present here, and it did run off into adjacent properties and into the right-of-way during storm events.
And it wouldn't have happened had they not denuded the property?
Had they properly addressed the site with silt fence, swales, grading, that would not have happened.
Okay. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a one-time fine for $2,000 along with administrative costs to abate this violation due to the irreparable damage of the area. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask the special master to find, never mind, not that part, sorry.
I adopt the county's proposed findings. I'll assess a one-time fee of $2,000 and incorporate other standard order provisions.
Thank you.
Thank you.
Next case on the agenda, Royal Silverstone LTD, case number 218-5826, Code Officer Brandon Norman. Page 28 of your agenda. Experts on the case, Jeffrey Atkin and Joanna Katir.
Are you doing all three of them together?
They're two separate addresses. So
Yeah.
which one did you call again? I'm sorry.
I called the first one.
The 5826?
Yes, 5826.
So this one is two violations on the same property. This is going to be case number 2185826, Development Applications Applicability, a violation of Chapter 4, Section 4002, A, B, and C of the Citrus County Land Development Code. This is also case number 2185827, accumulation of junk and debris, violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 4474 East Rejoice Street, Inverness, Florida 34453. Property owner listed as Royal Silverstone LTD. I have good service via signed certified mail return receipt, and I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, these are all taken at the same time as well.
Okay.
Exhibits A will be photos taken during the initial inspection on March 23rd, 2023, and the corrective action inspection on May 12th, 2023, and photos of my final inspection on June 19th, 2023. For case number 2185826, I would also like to, for Exhibit A, images of property appraiser for 2003, 2004, 2019, and 2022. Exhibit B for both cases will be copies of the notices of violation, a copy of the notice of hearing, and a copy of the signed certified mail return receipt.
Does anyone from the public want to be heard on either of these cases? No.
That's grading, and this is. They graded that and jumped it over here.
Okay, thank you. Without objection, what's been proposed as Exhibits A and B in each case are admitted as evidence.
On March 23rd, 2023, an initial inspection was conducted at the property for site modification without permits as well as junk and debris. Again, these violations were part of a larger investigations of the Inverness Villages 4 for reports of junk and debris as well as site modification. The property was found to be in violation of the above ordinances. The property remained in violation at my corrective action inspection on May 12, 2023, as well as my pre-hearing inspection conducted June 19, 2023. I haven't had contact with the property owners directly, but I have spoken with their attorneys, and their attorney informed us that they had no recollection or insight of any development occurring on the property. So all the actions that have taken place on the property they're unaware of. For the site,
Who are the attorneys?
I don't have their name on here.
You spoke with the attorneys?
Well, they emailed us.
They emailed.
Mm-hmm.
Did they email you? Who did they email?
Are you talking about, were they emailing me and you were copied?
I think I was copied on it, yes, ma'am.
And I don't know their.
Are they local or
No.
Are they Florida attorneys?
Yes, I think they're over there. They're in Central Florida.
Okay.
I don't. They said their clients were unaware.
Central Florida attorneys. I don't know.
Yeah, probably.
They think they just own the roads, and we got to put a stop to that.
But they were unaware of this. One of the, and I'm not sure it was these three because there are several properties this occurred to, and one of their clients came over to see what had happened, and they said somebody else was doing it. We believe we know who it was, but in any event, they're gonna. I told them the violation
Does it
still
matter?
existed.
I
No,
mean,
it does not because the violation occurred on the property, especially the junk and debris one. Because it needed to be cleared
that could
up.
at least be cleared. Is there any testimony from other county witnesses that you want to have?
It's the same for the previous case that was heard.
Okay.
There's no permit application.
There is no permit for this one, though.
Okay.
But the impact remains the same, though. Yes, great.
This case, like the other one you just heard, very similar situation. This particular case, they did site grading. And whenever you grade the site, now you're altering the path of runoff, you're altering the natural flow, and you're altering the topography of the land. That, in my expert opinion is a bigger violation than just stripping off the vegetative material, because now you're physically changing.
Why would someone grade it if it wasn't the owner's? It doesn't make any sense to me. Yeah, I'm curious.
That's what happened.
Yeah, I mean.
So
I'm not supposed to object.
immediately adjacent to this property, they are building a home. I've spoken with some of the subcontractors that are out there, and the way he's explained it to me is he's given a list of properties to clear and begin grading, and he doesn't go
Could
back.
be a survey error.
He doesn't go back to look. Well, this is what he's explained to me.
Okay.
He doesn't go and pull permits for that. He's given a list from the contractor that's hired him to do so, and he executes that list.
Okay.
In my belief, I think that they didn't realize probably what lot they were on. They
Well,
could've-
this happened recently in Citrus Springs for a client of mine. The survey was wrong, and then they built the home on the wrong lot. That came to it came to someone's. It came to building's attention at any rate, and it ended up all getting fixed, and the permit was, but it was a bizarre situation, and it was a survey error.
I was a little concerned too, because why would they grade that specific one lot?
Okay.
But I guess that's speculation.
Well,
at
it
best,
doesn't
so.
matter for the purpose of my job. So what's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the Special Master assess a one-time fine of $5,000 along with administrative costs for the site modification violation today. We request a daily fine of $100 a day for the junk and debris, along with the administrative costs to begin after the date that you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they are advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask the Special Master additionally to find that it's respondent's responsibility to contact the Code Compliance Division when the junk and debris violation has been abated in order to allow for reinspection.
What was the amount that the county recommended on the junk and debris case?
For the junk and debris, $100 a day.
100. Okay. I'll find in each case that there's a violation. In case number 218-5827, junk and debris, I will give 15 days from today to abate the violation. If it's not brought into compliance as ordered, a fine of $100 per day will be assessed. In case number 218-5826, I'll assess a one-time fine of $5,000 and incorporate other standard provisions.
Thank you.
Thank you.
Next case on the agenda is Cynthia L. Key.
Don't we have another Royal Silverstone?
Oh,
There is one more, but it's for site modification as well.
Is it for site mod?
It is for site modification.
For Royal?
Yeah,
For
just
Royal.
different.
It's just a different address.
Okay, I'm sorry.
Well, again, I'm not trying to, it's just, while we're on the, I actually
Okay,
would like
I
to
get
hear
it.
it next
Yes.
if possible.
Next case on the agenda, Royal Silverstone LTD, case number 218-5831. Code Officer Brandon Norman, page 30 of your agenda. Experts Joanna Coutu and Jeffrey Atkin.
This is case number 218-5831, development applications, applicability, a violation of Chapter 4, Section 4002, A, B, and C of the Citrus County Land Development Code. The address for this one is 4683 East J Street, Inverness, Florida, 34453. Property owner listed as Royal Silverstone LTD. I have good service via certified mail return receipt. I would like to authenticate the following documents and request they be admitted as evidence. Exhibit A will be photos taken during the initial inspection on March 23rd and the corrective action inspection on May 12th, 2023, and photos of my final inspection on June 19th, 2023, as well as aerial images from the Citrus County Property Appraiser website for 2021 and 2022. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, and a copy of the signed certified mail return receipt.
Is there anyone from the public who wishes to be heard on this case? Why wouldn't the attorneys have appeared or sent something? I mean, do you know why the attorneys aren't? Okay. Thank you. What's been proposed as exhibits A and B are evidence. Is there anyone from the public who wants to be heard in this case? Nope.
On March 23rd, 2023, an initial inspection was conducted of the property for the site modification without permits. As spoken before, this property was included in a larger investigation of the Inverness Villages 4 development for a complaint of site modifications without permits and junk and debris. This property was found to be in violation of the above ordinances due to not having any permits issued before the removal of trees from the lot. The aerial photos show that the trees were removed between December 2021 and October 2022. The removal of these trees has played, again, another major factor in the stormwater retention as well as the ecological issues affecting the residents in this development. As of my inspection on June 19, 2023, no permits have been applied for. Again, from the emails that I was CC'd on, no activity was made aware of by the property owners. They're completely unaware of the clear
County's
cutting.
recommendation?
The Citrus County Code Compliance Division respectfully requests that the Special Master assess a one-time fine of $5,000, along with the administrative cost to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask the Special Master, never mind, not that part either. I apologize, that's where I stopped.
The maximum I can assess is $15,000 on a one-time fine.
That one's pretty severe. It's a very large canopy area that was completely clear cut.
This one right here?
Yes, sir.
How big's the lot?
I believe measured out, I want to say it's 153 by 90. I don't know the diagonal portion of the lot.
1.24 acres according to the property appraiser.
Okay, I'll assess a one-time fine of $5,000 pursuant to the county recommendation and find that the property is in violation.
Thank you.
I'm just double checking that because we have so many rejoices. I want to make sure I have.
Sure.
Give me just a
I get
second
the
to double
Rejoice and
check
Jay
that.
mixed up a lot. That's one of the cases are bouncing back and forth.
I hear you.
Okay, we're gonna go back to alphabetical.
Okay.
Next case on the agenda, Camilla A. Breachin and Camilla Breachin Revocable Trust. Case number 2181953, Code Officer Brandon Norman, page 7 of your agenda.
We're about halfway through.
Getting there.
Maybe you can get a ticket going through rush hour traffic.
God willing.
I do want to let you know that this individual was here this morning.
Oh, really?
She had to leave. She's having some health complications. She's an elderly lady, but she wanted me to express to you that she wanted to stay here as long as she could. So.
All right, I appreciate that.
This is case number 2181953, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 5086 South Pastel Point, Homosassa, Florida 34446. Property owner listed as Brechen Camellia and Camellia A. Brechen Revocable Trust. I have good service via posting at the property and the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A will be photos taken during the initial inspection on February 17th, 2023, and the corrective action inspection on March 24th, 2023, and photos from my final inspection yesterday, June 20th, 2023. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, and a copy of the posting affidavit I completed, and photos of the posted notice of hearing.
Is there anyone from the public who wishes to be heard? Nope.
And on that last one, I did confuse Jay and Rejoice. That one was only 0.35 of an acre.
Thank you.
On February 17th.
Sorry, Exhibits A and B are evidence. Thank you.
Apologize. On February 17th, 2022, I conducted an initial inspection of the property for junk and debris. The property was found to be in violation of the above ordinance. I made contact with an occupant of the residence who identified himself as the son of the property owner. I informed him of the violation and how to abate it and come into compliance. The property remained in violation on March 24th, 2023 with little change. I made contact with the property owner on June 9th, 2023 when I posted the property for good service. I explained to her the same thing of why the property was in violation and how to come into compliance. As of June 20th, 2023, the property remains in violation. They have made significant progress, and from my understanding, it should be in compliance as of today, but I can't confirm that. She didn't have photos available.
I mean, I don't know if just throwing a tarp
That's yeah. She said that's completely gone
Okay.
now because I informed her of the same thing.
All right, what's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 a day, along with the administrative cost to begin after the date that you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask the special master to find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
I adopt the county's proposed findings of fact and law. The property is in violation. I grant 30 days from today to abate the violation. If it's not brought into compliance as ordered, a fine of $50 per day will be assessed.
Thank you.
Next case, next two cases. Jeanette Carroll and James Singletary, case number 218-2666 and 218-2668. Brandon Norman is the code officer, pages 8 and 9.
I'm going to take a break after these cases, probably a 10-minute break.
To let you know on this one, the property owner was here as well. She had to leave. She had to go pick up her mother from the hospital. So.
Okay.
But this will be case number 218-2666, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances, as well as case number 218-2668, abandoned, unserviceable, and unlicensed vehicles, a violation of Chapter 20, Article 4, Section 20-41 of the Citrus County Code of Ordinances. The address is 5340 West Starburst Lane, Homosassa, Florida, 34446. Property owner is listed as Carol Jeanette and Singletary James. I have good service via posting at the property in the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A will be photos taken during the initial inspection on February 27th, 2023, and corrective action inspection on April 6th, 2023, and photos of my final inspection on June 20th, 2023. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, and a copy of the posting affidavit that I completed, as well as the photos of the posted notice of hearing at the property.
Okay.
There was a previous case with this one as well that abated prior to. It was for RV occupancy, but they came into compliance on that.
Was that on my watch?
No, this was for at the same time that I did these inspections.
I see. Okay. Is there anyone from the public who wishes to be heard on either of these cases? No.
I was gonna say the first two pictures didn't look that bad.
Same pictures for both?
Same pictures.
Thank you. What's been proposed as exhibits A and B in each case are admitted?
On February 27th, 2023, an initial inspection was conducted at the property for junk and debris and unlicensed and inoperable vehicles. I had access to the neighbor's property on the initial inspection. That's how I got access to see the rear of the property. The property was found to be in violation of the above ordinances. The property remained in violation of my corrective action inspection on April 6th, 2023, as well as my pre-hearing inspection conducted yesterday, June 20th, 2023. I have had contact with the property owner as of yesterday. She contacted to let me know. She admitted that there is a truck in the backyard that's unserviceable. She hopes to have it trailered out of there this week.
Okay.
And then the junk and debris should be cleaned up as well. She let me know that she had sold the property, so she's in the process of.
She sold the property?
She has sold it. It hasn't reflected on the property appraiser's website, so as of right now, she's still the property owner. So I don't know if it just hasn't updated or not.
Well, no, she's not the owner. I mean, if she sold it, did she just tell you that?
She just told me that, yeah. That's why I tried to go on the property appraiser's website to confirm, but there was no way to confirm it.
Well, I mean, ownership is active upon the execution of a deed. It doesn't even need to be recorded. But then again, I'm not sure it matters. You have valid notice because it hasn't updated on the property appraiser. All right, what's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the Special Master assess a fine of $50 per day per violation, along with the administrative cost to begin after the date that you deem sufficient to abate these violations. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask the Special Master to find that it is the respondent's responsibility to contact the Code Compliance Division when the violations have been abated in order to allow for reinspection.
Are the attorneys looking at something relevant
We're
for
just
this
looking
case?
at the provision, and it's in the code and the statute, where if you transfer after the notice is given, then the owner is supposed to let the
New owner.
know.
Okay, that's news that I just got this morning.
What are
so.
you looking at?
19-53 sub E.
Okay.
And then it's taken right from the statute.
Oh yeah, I mean most of this is.
Yeah, and then there could be an issue of fraud if that's not done.
Interesting. Okay. If the owner of property is subject to yeah, and it puts an obligation to disclose the identity of the new owner and copies of the disclosures. A failure to make the disclosures creates a rebuttable presumption of fraud. The proceeding shall not be dismissed, but the new owner shall be provided a reasonable period of time to correct the violation before the hearing is held. But we really,
I asked her if she had a copy of the deed or anything on hand either, but again, she didn't have any of that stuff present with her this morning.
well, let's see.
She just told you that today?
Just today, yes, ma'am.
This is section 162.06, subsection 5, says if the owner transfers ownership between the time the initial pleading was served and the time of the hearing. I guess it would be the time of the hearing.
Yeah.
Even though we didn't know till the date of the hearing.
Right. We also don't know if it's been transferred.
That's why I asked her if she had a copy of the deed
Yeah.
or anything as well, so I could make a copy of it, but she didn't have any of that stuff.
Okay. I don't think that's enough for me to find that a transfer has occurred. So I'm going to go ahead and in each case find a violation. Plus we don't have the disclosures. In each case I'll find a violation and grant 30 days from today to abate the violation. In each case, if the violation is not brought into compliance as ordered, a fine of $50 per day will be assessed in each case.
Thank you.
Thanks. Okay, so I'd like to
that's right.
just take 10 minutes. It's 2:32. We'll be back at 2:42. Time is 2:42, and this hearing is back in session.
Next case on the agenda, Kevin Hart and Vicky L. Hart, case number 218-2712, Code Officer Amy Becker, page 14 of your agenda.
Amy Becker, Citrus County Code Compliance Officer, case number 218-2712, abandoned, unserviceable, and unlicensed vehicles, violation of the Citrus County Code of Ordinances, Chapter 20, Article 4, Section 20-41. The address is 1 Taft Street, Beverly Hills, Florida. The property owner is Kevin M. Hart and Vicky L. Hart. I have good service via posting of the property as well as the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on February 28th, 2023. Photo taken on March 17th, 2023 at my corrective action inspection. Photo taken on April 26th. Photo taken on June 7th, 2023 showing the posting of the property. And photos taken on my final inspection June 20th, 2023. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, and a copy of the posting affidavit.
Is there anyone from the public who wants to be heard in this case? Nope. Thanks. Okay, exhibits A and B are admitted.
On February 28, 2023, while conducting an inspection for another violation, I observed a pickup truck with no tag and no front passenger side tire at the property, which is a clear violation of the ordinance listed above. As of my final inspection on June 20th, 2023, the property remains in violation.
What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $150 per day, along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the special master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
I adopt the county's proposed findings of fact. The property is in violation. I will grant 30 days from today to abate the violation, and if it's not brought into compliance as ordered, $150 per day. Thank you.
Next case, Cynthia L. Key, case number 218-3249, Code Officer Brandon Norman, page 15 of your agenda.
Good afternoon. This is case number 218-3249, Special Requirements for All Accessory Structures, a violation of Citrus County Land Development Code, Section 3102A. The address is for 4936 South Roebuck Way, Homosassa, Florida, 34446. Property owner is Key Cynthia L. Good service via posted at the property in the Canto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A will be photos taken during the initial inspection on March 9th, 2023. And corrective action inspection on April 11th, 2023, and photos of my final inspection on June 20th, 2023. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the posting affidavit that I completed, as well as a photo of the posted notice of hearing.
Is there anyone from the public who wants to be heard on this case? Nope.
Have they live in it?
Thank you. Exhibits A and B are admitted as evidence.
On March 9th, 2023, an initial inspection was conducted at the property for RFP on a vacant lot. This property was found to be in violation of the above ordinance. The property remained in violation of my notice of violation, corrective action inspection on April 11th, 2023, as well as my pre-hearing inspection conducted yesterday, June 20th, 2023. I have had no contact with the property owner at this time.
What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $100 per day along with administrative costs to begin after the date that you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the special master find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
What's the zoning?
For this one, it's just residential. It's listed right now as a vacant lot.
What type of residential?
I don't have that information right in front of me. I
Okay.
apologize.
So on any residential lot, it's got to have a principal use before you have the accessory structure. There's no permit that's been pulled that would allow this RV to be there?
There's been no permits that have been pulled. And as of right now, it's just been listed as vacant. And as of yesterday when I checked, no permits have been pulled at all. And again, no contact with the property owner.
What's the county's recommendation?
The Citrus County Code, did I just say it? No?
Maybe you did. What was the fine amount you recommended?
$100 a day.
100?
Yes, sir.
I will adopt the county's proposed findings of fact. The property is in violation. I'll grant 30 days from today to abate the violation. If it's not brought into compliance as ordered, a penalty of $100 per day will be assessed.
Thank you.
Thanks.
Next case, Judy La Puma, case number 218-6578, Code Officer Amy Becker, page 16 of your agenda.
Amy Becker, Citrus County Code Compliance Officer, case number 218-6578, accumulation of junk and debris a violation of the Citrus County Code of Ordinances, Chapter 20, Article 3, Section 20-31A. The address is 34 Davis Street, Beverly Hills, Florida. The property owner is Judy La Puma. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on April 11th, 2023. Photos taken on April 26th at my corrective action inspection. Photos taken on my final inspection June 20th, 2023. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, and a copy of the certified mail return receipt signed for on May 9th, 2023.
Is there anyone from the public who wants to be heard on this? No? Thank you. Exhibits A and B are evidence.
On April 11, 2023, I conducted my initial inspection for accumulation of junk and debris and observed a dump trailer filled with debris, which is a clear violation of the ordinance listed above. As of my final inspection on June 20th, 2023, the trailer and the debris have been removed. However, there's a refrigerator on the carport and a pile of vegetative matter in excess of 18 inches in the backyard.
Was the refrigerator there in April?
No, the refrigerator was observed on 6/2.
6/2, okay.
And I've talked to the owner and the tenant. They're gonna remove the refrigerator and remove the vegetative matter.
Is the fridge operational?
I didn't ask her if it was operational.
Okay.
But I did tell her she could keep it if she wanted to plug it in and use it. It's not in use right now.
How long has the vegetative matter been there?
Since the beginning, since April 11th.
Really? So that pile in the back, it's been there since April?
You'll see a big log. In other words, you
I
couldn't
see
see
the
it with
log.
the truck. When the truck was there,
Mm-hmm.
you couldn't see it.
Okay.
And then once the truck is gone, you'll see a big log and a pile of vegetative matter.
Okay. I see the log.
But I did reach the owner. She was very receptive.
Okay. What's the county's recommendation?
Why are you smiling?
It's just close to me. It's close.
The ordinance reads that excess vegetative matter. I mean, that's per.
But it's also
that's how
not a
the code-
violation
the
if
code
someone
reads.
has vegetative matter just there for a day or two and they haven't picked it up.
But this has been since April 11th.
I can't see that. I mean,
Okay,
it's-
I understand what you're
I've got
saying.
your testimony, and that's
Okay, I
evidence,
understand
and it's
what you're saying.
unrebutted.
Okay.
So I'm not really disputing it. I'm just saying it's close.
Okay.
You know, the fridge. I get what you're saying. The fact that it's been there since June 2nd. But anyways, I just have to think these
But that's
things.
not me saying, it's the ordinance saying that if it's an appliance, it's not allowed to be there. It's not me, it's the ordinance, it's the way it's written.
I don't think so. I think that if it was plugged in and it was being used out there, I don't think it would be junk.
Right, and I told her that.
I know, but the difference between something that's plugged in and not plugged in, so if she intended on using it out there, I don't know that I would find it a violation even if it wasn't plugged in because it's not junk. But it has to. She's not here to offer that kind of testimony. And you testified it's been there for 18 days unplugged. So I agree, but I think it's close. So
Okay.
what's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day, along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the special master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
I adopt the county's proposed findings of fact and law. The property is in violation. I'll grant 30 days from today to abate the violation. If it's not brought into compliance as ordered, a penalty of $50 per day will be assessed.
Thank you.
Thanks.
Next case, George D. Martin and Angela M. Martin, case number 218-0428. Code Officer Cody McGuire, page 17 of your agenda.
Cody McGuire, Citrus County Code Compliance Officer. Case number 218-0428, excessive growth and accumulation of vegetation, a violation of Chapter 20, Article 6, Section 20-61 of the Citrus County Code of Ordinances. Address is 8415 West Wings Lane, Crystal River, Florida. Property owner George D. Martin, Angela M. Martin. Good service posting the notice of hearing at the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during initial inspection on January 26, 2023, corrective action inspection on March 20th, 2023, and photos of my final inspection conducted on June 20th, 2023. Exhibit B, copy of the notice of violation, copy of the notice of hearing, copy of the posting affidavit, and a photo of the notice of hearing posted on the property.
Is there anyone from the public who wishes to be heard on this case? No. Thank you. Exhibits A and B are evidence.
On January 26, 2023, I conducted an initial inspection and observed the property to be in violation. On January 20th, a notice of violation was issued for excessive growth and accumulation of vegetation, which is a violation of the ordinance listed above. On March 20th, 2023, I conducted a corrective action inspection and observed the property remained in violation. I've had contact with the property owner who stated it had been that way for years. As of my final inspection on June 20th, 2023, the property remains in violation.
Cody, could you confirm the date of the notice of violation for me? Because you stated your initial inspection was January 26th and the notice of violation was January 20th.
30th.
Yep, what's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assesses a fine of $150 a day along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. We would also ask the special master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
I adopt the county's proposed findings of fact. The property is in violation. I'll grant 15 days from today or from the date of the order to abate the violation. And if it's not brought in compliance as ordered, a penalty of $150 per day will be assessed. Thank you.
Next case, Karen Lee Mashad and Ken Marr Revocable Living Trust. Case number 218-1593. Code Officer Brandon Norman, page 18 of your agenda.
Hello, Brandon Norman, Citrus County Code Compliance Officer. This is case number 218-1593. Accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 5185 East Old Stump Court, Floral City, Florida. 34452. The property owner listed as Mashad Karen Lee and Kenmar Revocable Living Trust dated February 21st, 2017. I have good service via signed certified mail return receipt, and I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A will be photos taken during the initial inspection on February 14th, 2023. My corrective action inspection photos on March 20th, 2023, and photos of my final inspection conducted June 19th, 2023. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, and a copy of the signed certified mail return receipt.
Is there anyone from the public who wants to be heard on this case? Nope. No.
You want
Very.
the public to see?
I'm just laying a record. You never know what objections might be raised on appeal.
I know. I've seen them all.
I know. Have there been appeals of my orders before?
No.
There's never been an appeal?
No.
I don't think so.
There were two of the previous special master, but none of yours yet.
You had two on
Greg.
my predecessor?
Mhm.
The whole time he was here? Two?
Oh, I think
That during my time.
During while you were here?
Yeah.
Okay. That's extraordinary.
there was more than that. Because when I think there was probably been about 10, maybe.
Yeah.
Since you've been doing it.
Well, Denise, there was a whole slew of them that were Greg's for Mr. Brennan's.
Was
with Schodenheim? There was a
Showburn.
Showburn.
Yeah.
Did Greg take over for Michelle?
Yes.
So Michelle was here before Greg.
Yes.
And that's the order. It was Michelle, Greg, Christian.
Yeah, and Mike Kovac was the alternate during Michelle Lieberman.
Really?
Yeah.
What's been proposed as exhibits A and B are evidence?
On February 14th, 2022, I conducted an initial inspection of the property for junk and debris. The property was found to be in violation of the above ordinance. The property remained in violation on March 20th, 2023, with little change. As of June 19th, 2023, the property remains in violation. There has been some change, but still it's in violation. I have had contact with a family member of the property owner who stated they are in the process of evicting the tenant. So as soon as they can get them out, they'll get someone in there and contract out a cleaning service to get it taken care of.
If Michelle Lieberman was presiding over this case, it'd be a $900 fine per day. So I'm joking, Michelle. I'm half joking, but let's see.
I haven't had contact with a resident or anything. So.
Okay. What's the county's proposal?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with administrative costs to begin after the date that you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the special master find it is respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
What was the amount?
50.
50.
I've had contact with them. They understand the violation. They're making efforts to get it cleaned up. It's just that the tenant is non-responsive.
Okay. I adopt the county's proposed findings of fact. The property is in violation. I'll grant 30 days from today to abate the violation, and if it's not brought into compliance as ordered, a penalty of $50 per day will be assessed.
Thank you.
Thank you.
Renee Molina and Janice Molina, case number 2185834, Code Officer Brandon Norman, page 19 of your agenda.
Case number 2185834, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. This address is 4527 East J Street, Inverness, Florida 34453. Property owners is Molina Renee and Molina Janice. I have good service being posting at the property in the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Photos taken during initial inspection on March 23rd, 2023, and a corrective action inspection on May 12th, 2023, as well as my final inspection on June 19th, 2023. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, and a copy of the posting affidavit that I completed, as well as the photo of the posted notice of hearing.
Is there anyone from the public who wishes to be heard on this case? Let the record reflect there's no response. There have been so many threats of appeals over the years. I'm just surprised.
I think Can they find out how much it costs?
With a lawyer, but you don't need a lawyer.
But even the filing fees are $400.
Yeah, the filing fees are outrageous. But I think you can apply
You can.
to have it waived.
Indigency.
Indigency, yeah.
Or
Thank you.
even a payment plan, I think.
All right, so it's just the property looks so similar to the other J Street.
They all look the same.
Okay, so without
So I had to
objection, what's
walk
been
them out.
proposed as exhibits A and B as evidence. It's like I could have sworn I saw this photo
It
earlier.
was like Lewis and Clark. I
Yeah.
had to physically walk out landmarks and stuff up there.
I got you. Yeah.
On March 23rd, 2023, an initial inspection was conducted of the property for complaint of junk and debris being brought into the property. This property was included in a larger investigation of the Inverness Villages for development for large amounts of tree debris being brought into the area and being discarded. The property remained in violation of my corrective action inspection on May 12th, 2023, as well as my pre-hearing inspection conducted on June 19th, 2023. I have had no contact with the property owners at this time.
This does raise, I mean, it is a good question. How did you determine that this is the lot? Because they all...
So initially there weren't any stakes or anything out there, so I had to do I had the property appraiser's website and GIS up, looking at landmarks, looking at what used to be there, and essentially having to measure out the distances.
How did you measure out the distance?
The lots are, I believe, they're 90 feet wide.
They should be about 90
So I had to
feet.
count out 90
Okay.
feet based on landmarks and stuff that were out
What
there.
I mean is, how did you figure out the 90 feet? I mean, did you use
With
an
the-
app?
I
You
used
did.
the
You
roller.
used one of the rollers.
One of the rollers.
Okay.
Yes,
all right.
sir.
Old school.
That's
I don't-
fine. I'll accept it.
It was
I
either
just.
that or I was going to count my steps tail to toe, but
I
I'm
mean,
not quite
I'd
12
probably accept that too.
it wasn't an easy task. I've spent a lot of man
That's the
hours
thing.
out
These
there.
are what, 90 by 150 or something like
Mhm.
that.
Yeah. For the square lots, they're 90 by 150.
So I'm just looking at the photos. So that's on the 150 foot. That's within.
Well, I haven't walked onto the property, so it is based off of an estimation on my behalf for the 150 portion of it. Then within 90 it's within the 90 feet for that lot.
I don't question the 90. I'm just.
There's so much debris out there that a lot of it flows over. A lot of it's sitting on multiple lots at the same time. They're in the process right now of burning off a lot of the debris. As you can see from the photos, there has been progress made.
You didn't have did you have contact with the owner?
I've had no contact with the
Yeah.
property owner. Every contact I've had out there has been with a subcontractor.
And they list the owner's address is the J Street address.
For the mailing address, it's not the J Street.
Oh,
for
it's not.
No, I'd have looked at the notice.
It's
of
in Lake
violation.
City. Okay.
Yeah.
All right. Well, I mean, it's unrebutted evidence. So, what's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $100 per day along with administrative costs begin after the date that you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the special master find it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection. The reason for the $100 a day is I had a case for site modification for the same address. They got their permit for it, so they came into compliance for that one. So I have to believe that they're
getting
aware
notice.
of the
Okay.
junk and debris somehow.
All right. The property is in violation. I'll grant 30 days from today to abate the violation, and if it's not brought in compliance as ordered, a fine of $100 per day will be assessed.
Thank you.
Thanks.
Next case, Kathy Jill Morantz and Maxwell L. Morantz. Case number 218-6894. Code Officer Julie Wilkinson, page 20 of your agenda.
No, that's case number 218-6857.
What?
I've got two. There's
Page 21 is
That's right,
the
I'm
case
sorry.
number you read. So
There's-
I assume both will be presented.
Yes, I'm sorry.
Okay.
Julie Wilkinson, Citrus County Code Compliance Officer, case number 218-6857, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. In case number 218-6894, excessive growth and accumulation of vegetation, a violation of Chapter 20, Article 6, Section 20 through 60 of the Citrus County Code of Ordinances. The address is 46 Jamaica Street, Homosassa, Florida 34446. Property owner is Morantz Kathy Joe and Morantz Maxwell L. I have good service via certified mail signed return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during an initial inspection on April 14th, 2023, compliance and the corrective action inspection on May 10th, 2023, and photos of my final inspection conducted on June 20th, 2023. Exhibit B, a copy of the notices of violation, copy of the notices of hearing, and a copy of the certified mail signed return receipts.
Is there anyone from the public who wishes to be heard on these cases? No.
These are the current owners.
Thank you. What's been proposed as exhibits A and B in each case are admitted. Go ahead.
On April 14th, 2023, I conducted an initial inspection and observed the property to be in violation. On April 14th, 2023, a notice of violation was issued for junkyard conditions and excessive growth and accumulation of vegetation, which is a violation of the ordinance listed above. On May 10th, 2023, I conducted a corrective action inspection and observed that the property remained in violation. I have had contact with the property owner's son on June 20th, 2023, which was yesterday. As of my final inspection on June 20th, 2023, the property remains in violation.
So I definitely see it on the overgrown grass case. On the junk case, what's been prominently featured is this overturned wheelbarrow.
Mm-hmm.
What else constitutes the junk and debris?
There's some plastic totes and lids and 5-gallon plastic buckets out there. They did clean up there has been some cleaning up been done.
I mean, buckets?
Mm.
What else?
That's it.
Are you sure?
Oh, there's a tarp.
Where's the tarp? Where is the tarp? I mean, I see a lawnmower. Help me find the junk here.
Okay.
But what's that? What is that? A white
That's a bucket.
bucket.
Mm-hmm.
Yeah, the wheelbarrow. Let me see the tarp. I just don't see it. Okay. And the crates. The crates?
Yeah, well, those are, I guess you can call them crates, but I thought they're plastic totes.
What? Well, yeah. I mean, I just call them crates, but yeah, I hear what you're saying. So are they called totes? No, I'm just wondering. That's interesting.
What I call them.
Okay. I've been using totes all my life. I didn't even know it. I know you don't like to hear me say it. It's close to me.
I get it.
Mm-hmm. That wheelbarrow does not look good. It doesn't look particularly usable. It doesn't look usable at all. It does look like junk. So I will find that there's a violation. Does the county attorney's office think that buckets are junk under the...
Are they full of water and mosquito larvae?
I can't tell.
So I cannot get on the property to determine that, but they could very easily be filled up with water and become a sanitary nuisance at the same time. So that's why I consider it to be junk.
junk defined? See, it's junk.
Abandoned property, construction or demolition debris, litter, waste materials of any kind used.
I mean, junk includes used and non-functional tools, equipment, and implements. But gosh, that could include just about anything.
Is a bucket construction debris?
Not in my view. Abandoned property shall mean wrecked or derelict property having no value other than nominal. I just want to give guidance for what the violation is.
Debris is material stored externally, exposed to the elements and not otherwise completely enclosed by a walled roof structure, and shall include, but is not limited to, discarded household items. That would be a bucket.
Scrap or discarded plastic, paper, cardboard, plumbing fixtures, and other building material. Discarded in the garden. And that white bucket almost looks like a tank.
Propane tank?
No, but I mean, no, it's a bucket. It's just overturned.
Oh.
So there's no water in that.
No water accumulating.
No water in that.
But there's a lot more than just that white bucket.
There's a lot of buckets.
Mm-hmm.
But they're in the garden area. I mean, dang it. When you went and visited yesterday, I see an orange overturned bucket, but there's also like a wall or something. I can't, what is this thing right here? Here's the bucket. What's that?
I can't recall what that was.
Okay. It's hard to.
I think it's one of those big plastic heavy duty wheelbarrows, garden wheelbarrows that's just like.
Oh, it's just up. You're right. That's exactly what it is. Yep. Okay, I see the wheel.
But that one's in good condition, so I don't care
No,
about that.
yeah, that's not junk.
Yeah.
The other wheelbarrow is for sure. Oh, gosh. In a position where, buckets that could be used for putting dirt in and transferring things. And if I find that it's junk, then basically what you're saying is they can't have buckets out in the garden where they're most convenient, or they just have to be enclosed and brought out every time they're being used.
I understand what you're getting at.
That's what I do.
I don't have buckets.
I mean, I do too. I use buckets for gardening at home, but
We do too.
store them away, and they're definitely not collecting water and creating an issue for my neighbors.
I mean, the reason why they're next to the wheelbarrow. You usually tell me that the difference for y'all is whether it's being used or not, or it's usable. And granted, there is going to be junk that's usable, but it's just strewn around, and it would still be junk. Used or non-functional tools. Used and non-functional tools. Okay, so it's not that. Okay, it's not junk. The question is it debris? Well, what about vegetative matter? Is vegetative matter a part of this?
Yes, sir. Would you like me to come up and show?
Yeah, I mean, that would.
So it's this pile right here.
Okay.
I guess it's not showing well in the photo, but it's this.
Well, that's the overgrown. I'm gonna find.
Yeah. So
that.
it's a bunch of palm frond leaves and other.
Okay. All right.
Stuff.
What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests the special master assess a fine of $50 per day, along with the administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they're advised of the violation. We would also ask the special master additionally to find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
All right, in case number 218-6894 for the overgrown grass, the property's in violation. I'll grant 30 days from today to abate the violation, and it'll be $50 per day if it's not brought into compliance as ordered. In case number 218-6857, the property is in violation due to the wheelbarrow, the vegetative matter, and I can see it both ways on the pails and the buckets. I'm going to find that it is a violation based on the number and placement and overturned nature of the buckets. What I would say is that for that particular violation, it would be abated if they were demonstrably being used and not just stacked like junk in a pile. Okay?
Mm-hmm.
And if it's, I'll give 30 days on that, and if it's not brought in compliance as ordered, fine of $50 per day. Thank you.
The next two cases, Principal Partners Group LLC, case number 218-6765 and 218-6766, pages 24 and 25 of your agenda. Oh, and Julie Wilkinson is the code officer.
Bless you. Yep.
Julie Wilkinson, Citrus County Code Compliance Officer, case number 218-6765. Accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. And case number 218-6766, unlicensed inoperable vehicles, a violation of Chapter 20, Article 4, Section 20-41 of the Citrus County Code of Ordinances. The address is 1540 South Charles Drive, Homosassa, Florida. Property owner, Principal Partners Group, LLC. I have good service via certified mail, signed return receipt. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during an initial inspection on April 13th, 2023. Corrective action photos taken during a corrective action inspection on May 15th, 2023, and photos of my final inspection conducted on June 20th, 2023. Exhibit B, a copy of the notices of violation, a copy of the notices of hearing, and a copy of the signed certified mail return receipt.
Is there anyone from the public who wants to be heard on these cases? No.
Painted nicely.
Without objection, what's been proposed as Exhibits A and B are evidence. Please.
On April 13th, 2023, I conducted an initial inspection and observed the property to be in violation. On April 13th, 2023, a notice of violation was issued for junkyard conditions and unlicensed vehicles, which is a violation of the ordinances listed above. On May 15th, 2023, I conducted a corrective action inspection and observed the property remained in violation. I have had contact with the property owner. As of my final inspection on June 20th, 2023, the property remains in violation.
Does the owner understand what's being alleged by the county? That
Yes.
it's in violation?
Yes.
Okay. I mean, is the owner going to do something about it?
Yeah, they have started cleaning it up.
Okay.
It's just not finished yet.
Okay. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day per violation, along with the administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. We would also ask the special master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
The property is in violation in each case. In each case, I'll grant, well, it actually looks like there's a decent amount to do. I'll grant 60 days in each case to bring the property into compliance, and if it's not brought into compliance as ordered, a fine of $50 per day will be assessed in each case. Thank you.
Next case, Michael Ray Stump, case number 2185668, Code Officer Brandon Norman, page 32 of your agenda.
Brandon Norman, Citrus County Code Compliance Officer. This is case number 2185668, Development Applications, Applicability, Violation of Chapter 4, Section 4002, A, B, and C of the Citrus County Land Development Code. The address is 4531 East Rejoice Street, Inverness, Florida, 34453. Property owner listed as Stump, Michael Ray. I have good service via posting at the property and the Lecanto Government Building. I would like to authenticate the following documents and request to be admitted into evidence. Photos taken during the initial inspection on March 23rd, 2023, my corrective action inspection on May 12th, 2023, and my final inspection on June 19th, 2023, as well as aerial images from the Citrus County Property Appraiser website for 2021 and 2022. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, and a copy of the posting affidavit that I completed, and photos of the posted notice of hearing.
Is there anyone from the public who wants to be heard in this case? Nope. Thank you. Okay, what's been proposed as Exhibits A and B are evidence.
On March 23rd, 2023, an initial inspection was conducted at the property for site modification without permits. The property was found to be in violation of the above ordinances due to not having any permits issued before the removal of trees from the lot. The aerial photos show the trees were removed in between December 2021 and October 2022. As of my inspection on June 19th, 2023, no permits have been applied for or issued. I have not had contact with the property owner.
Okay, what's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a one-time fine of $5,000 along with the administrative cost to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and its irreparable damage to the area.
All right, I'll assess a one-time fine of $5,000 and find that there is indeed a violation of this code section.
Thank you.
Final two cases. Christina Townsend, case numbers 2184633 and 2184829. Code Officer Brandon Norman, pages 34 and 35 of your agenda.
This is case number 2184633, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances, as well as case number 2184829, abandoned, unserviceable, and unlicensed vehicles, a violation of Chapter 20, Article 4, Section 20-41 of the Citrus County Code of Ordinances. The address is 6359 West Pershing Drive, Homosassa, Florida 34448. Property owner listed as Townsend Christina. I have good service via posted at the property and the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A will be photos taken during the initial inspection on March 15th, 2023, my corrective action inspection on May 8th, 2023, and photos of my final inspection on June 20th, 2023. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, and a copy of the signed certified mail return receipt, as well as the I apologize, I didn't have certified mail return receipt. It's a copy of the posting affidavit that I completed, as well as the posted notice of hearing at the property. My apologies.
Okay. Is there anyone from the public who wants to be heard on either case? Nope.
So I have three votes. That should be back on. That's part of the other one. The other vote is back right there. It's on the same blocks.
So that one's different than that one. Okay.
Thank you. Exhibits A and B in each case are admitted as evidence.
On March 15th, 2023, an initial inspection was conducted at the property for a report of junk and debris and unlicensed or unserviceable vehicles. I did have a complaint for RV occupancy. They allowed me the inside and see that it was just being used for storage, so I closed that one out. My inspection found the property to be in violation of those two ordinances. I observed little change at my compliance inspection on May 8th, 2023, and as of June 20th, 2023, some progress has been made, but it still remains in violation. I have had contact with the property owners, and they're working to bring into compliance. One of them was here this morning. Again, he had to leave due to some other conflict. He didn't disclose to me.
Okay. Yeah, a lot of people fled.
I was very polite to everybody, so I don't think so. I think it was me. They've been since I've made contact with. I didn't have initial contact with them, but since I've made contact, they've been pretty responsive as far as keeping me updated and stuff like that, and letting me know what they plan to do. As of right now, for the unlicensed unserviceable vehicles, it's the three boats. There's one in the wood line. You'll see the boat named Family Affair. There's another one on the trailer with a flat tire, and then he admitted that the one on the cement blocks is not registered at all. And then the SUV that was my initial inspection was removed from the property. And the thing next to the one boat on the trailer is a tanning bed.
Okay, I see it. What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day per violation, along with administrative costs to begin after the date that you deem sufficient to abate these violations. These amounts were selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to these violations. We would also ask the special master to find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
In each case, the property is found to be in violation. In each case, I'll grant 30 days from the date of the order to abate the violation, and if it's not brought into compliance as ordered in each case, a penalty of $50 per day will be assessed.
Thank you.
That was the last case.
Thank you for your time.
No problem. Is there anything else the county wants to take up before the hearing is adjourned? Okay, the time is 3:34. The hearing's over.